Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2 in Jefferson County, Texas. This morning, we have 3 dockets. We have our trial docket, our pretrial conference docket, and our announcement docket. When I call your name, please come forward with your attorney. If your attorney is not here, your attorney is probably in another court handling another matter, and we'll wait for your attorney to arrive. Aaron Lawrence Buller. Mr. Buller, your full name is Aaron Lawrence Buller.
Yes, sir.
How are you doing, Mr. Buller?
Okay.
Okay, that's good. Now, Mr. Buller, you're represented by your attorney, James Macon. Attorney Macon, how are you doing?
I'm good Monday, Your Honor. I'm here.
Okay. State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Same announcement, Your Honor.
Okay. Now, Mr. Macon. Okay, what is your announcement in Mr. Buller's case?
Your Honor, I don't know if it shows it, but Mr. Trichter is co-counsel on Mr. Buller's case,
No.
and I'm announcing ready for trial.
Okay, but this is on the pretrial conference docket.
Yeah.
Okay, so let's put it on a trial docket. Okay, this case will be set for October 7th of 2024. Mr. Buller, your attorney, get your reset. Once you get your reset from your attorney, you're free to go.
Yes, sir.
Stay in contact with your attorney, your bondsman, and you have a blessed day.
Yeah.
What case is that? Okay.
What do I need to do? Do what thing to put down in?
Where is it? It should have a spot on there.
Okay.
That don't block Mr. Williams. Again.
Next case is cause number 23 CCCR 1502, case of style of state of Texas versus Tyreka Tennille Barnett.
Your Honor, on those cases, the state will have motions. They have just been submitted to the clerk's office because I had to deliver the copies of the motion by hand. They didn't have email information to
Okay,
serve Mr.
what kind of motions?
For continuance, Your Honor, due to the absence of an officer.
We're not voting for this one.
Okay, so you
Just
say,
these states first.
okay, and you said you're not opposed?
Correct.
Okay. Ms. Burnett, your case, so you have motion in both cases?
Yes, Your Honor. There's a common investigating officer in both cases.
And you don't have any objections to that motion either? Okay, now, Ms. Burnett, your cases will be continued. Your attorney is not objecting to the state's motion for continuance, their first motion for continuance in this case. Court is going to grant it. And you're gonna get your reset from your attorney. Once you get your reset, you're free to go. Stay in contact with your attorney and your boss.
Yes, sir.
Okay,
Pictures.
okay, you're welcome. He has another case. Ms. Mosby, is Miss Corbin back there?
Yes.
You,
You need her out right now?
you need time to talk to her?
Well, I talked to her this morning, but, I was trying to figure out how to work the machine, so I gotta.
Oh, okay,
we're
okay,
gonna-
we'll hold.
We're gonna lead her to that.
Okay. Okay.
No, I gotta figure out how.
Okay. Next case is cause number 23CCCR 1966, cause number 23CCCR 1967, and cause number M333072. All three cases style of state of Texas versus Charles Jason Kramer. Mr. Kramer, your full name is Charles Jason Kramer. How are you doing, Mr. Kramer? I'm doing fine, thanks for asking, Mr. Kramer. You represent your case by your attorney, Attorney Ryan Matuska. Mr. Matuska, how are you doing?
Good morning.
State is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm good, Judge. How are you?
I'm doing fine, thanks for asking. Now, Mr. Matuska, what's your announcements in Mr. Kramer's cases?
Your Honor, we're ready.
Okay.
I think we're gonna kind of go on one case as
That's correct.
existing, but we plan on filing motion to consolidate those today.
Okay,
Two of
so,
them are city appeals.
yeah, okay, so you say Kramer, okay, ready, state ready, okay. So I think we have a jury coming at 1:30 today. Be back at 1:30.
Sure.
We'll give the trial order. And right, we have several cases. You're the first one when we call.
Your Honor, I have to be down hall at 1:30, but as soon as I'm done, I'll come over.
Okay, you have to be in district court. Okay, that's
Yes,
good. Okay, we're gonna see you at 1:30. John Michael Shear. He's on Zoom.
Filling in for the attorney of record in this case.
Ben Florida, okay. Who's the prosecutor? Okay, this is cause number 23CCCR 0480. Case is filed in the state of Texas versus John Michael Shear. John Michael Shear is appearing via Zoom. Mr. Shear, how are you doing?
I'm doing well, Your Honor. How are you this morning?
I'm doing fine. Thanks for asking. Now, Mr. Shear, your attorney of record is Attorney Justin Eaton. Attorney Eaton is, yeah, no, I'm saying, but Attorney Eaton is not here. However, standing in for Attorney Eaton is Attorney Ben Floyd.
My name's Alec Clifford. The attorney of record has been Floyd. Probably hasn't filed a formal notice of appearance yet, but this case has been going on for quite some time with our office.
Okay, if he had filed a formal notice, he's not the attorney of record.
Well, I know he's been in communications with.
Yeah, but he has to file something.
Correct.
Okay, because the docket sheet shows Justin Joe Eaton.
Mhm.
Is he still with the firm?
No, he's not.
Okay, matter of fact, I think when, Ben Flory came in the last time, he mentioned that he was gonna file a letter of representation. Could we check to see if he filed that letter of rep? He did? Okay, so he did, his name need to be changed on that. Okay. Okay, so Mr. let's see. Are you're Alec
Yes.
Comerford?
Yes, Judge.
Okay. Okay, Mr. Shear, your
Yes, sir.
attorney of record is Attorney Ben Flory. Attorney Flory is not present. However, standing in for Attorney Flory is Attorney Alec Comerford. Does, Mr. Comerford have your permission to stand in for Mr. Ben Flory?
Yes, Your Honor.
Okay, now, Mr. Comerford, how are you doing?
Good, Your Honor. How about yourself?
I'm doing fine, thanks for asking. Now, what's your announcement in Mr. Shear's case?
We're still waiting for some media, and so we're gonna need to reset. I know they were just trying to look for some more video footage.
Okay.
So we just need some more time for that.
Okay. Okay, give us a reset, gonna keep it on the announcement docket. Okay, this case will be reset to October 7th of 2024. Mr. Shear, stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Thank you, Your Honor. You too.
Okay, you are. Next case is cause number 23 CCCR 0974. Case is style of State of Texas versus Addisay Trevino.
What docket is this one, Judge?
This is same announcement docket, page 2.
This is my case.
Yes. Yeah, it has you down. And Mr. Trevino, how are you doing? Okay. Mr. Trevino, you're representing this case by Attorney Alec Comerford. Mr. Comerford, what is your announcement in Mr. Trevino's case?
Still waiting media discovery. Need to pick that up, so we just need to reset.
Okay, now, give us a reset, probably gonna reset on the same day, October 7th, 2024. Yeah, this case will be reset to October 27th, 2024. Mr. Trevino, you're gonna get your reset from your attorney. Once you get your reset, you're free to go stay in contact with your attorney and your bondsman. And you have a blessed day, and Attorney Comerford, once you get your reset, you're free to go and you have a blessed day as well.
Here's what it is.
You're welcome. Thank you. Let's see. Next case is cause number M319621, case of style of State of Texas versus Severio Israel Gonzalez. Mr. Gonzalez,
Yes, sir.
your full name is Severio Israel Gonzalez?
Yes, sir.
How are you doing, Mr. Gonzalez?
Very good.
That's good, Mr. Gonzalez. You're representing your case by your attorney, Ben Jeffers. Attorney Jeffers, how are you doing?
Doing well, Your Honor. How are you?
I'm doing fine, thanks for asking. Mr. Jeffers, what is your announcement in Mr. Gonzalez's case?
We've
come to an agreement with the state that it's just gonna require maybe one more reset in order for Mr. Gonzalez to complete a few things, and it should be dismissed.
That's correct.
Okay, well, let me say complete a few things. How long is it gonna take for him to complete it?
The requirements are restitution of that class, Your Honor.
2 or 3 weeks should be sufficient.
Okay. Give us Ms. Jackson, give us a reset for about 2 or 3 weeks. Yes,
No, in another county on that day, but usually things are resolved.
Then it should be dismissed.
okay. September 9th. So this case is reset to September 9th, 2024. Mr. Gonzalez, you're gonna get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go. Stay in contact with your attorney and your boss. And you have a blessed day. And Mr. You have another one.
David Torres, who's running concurrently with his felony cases. I believe it's all. tied together.
Are you talking about the offer?
Oh, no, I'm talking, all his cases are tied into. with
Yeah, yeah.
felonies.
So what's going on with the felons?
I'm not in the loop on the felonies.
Okay, he set, I imagine he set the date. Because we need to find out what's going on with his felonies. So what I can do is, we'll just give you some time. You probably need to check with whoever the felony defense attorney or prosecutor is. Grove, okay, okay, so we'll put it on hold and we'll call you back,
Yes, sir.
give you time to find out some information on it. Okay, Mr. Lane. Oh, she's not here, huh? Aaliyah Johnson,
Yeah, she just got here, sir.
please come forward. Okay, this is cause number 23CCCR 1864, case of style of the state of Texas versus Aaliyah A. Johnson. Ms. Johnson, is that your full name?
Yes.
How are you doing, Ms. Johnson? I'm doing fine, thanks for asking, Ms. Johnson. You're representing your case by your attorney, Brian Lane. Attorney Lane, how are you doing?
Hi, Your Honor.
And Mr. Lane, what is your announcement in Ms. Johnson's case?
Your Honor, I'm respectfully going to ask for one more announcement. Recently been retained by Ms. Johnson. I think her former attorney was getting off her caseload. She reached out to me and I haven't been able to get, I don't have discovery and I haven't gone over discovery with her.
Okay, how much time do you need?
30 days, 60 days.
Okay. Give us a reset date, September 30th. Okay, this case is set for September 30th of 2024.
Thank you.
Once you get your reset, you're free to go.
Thank you, Judge.
And once you get your reset from your attorney, Ms. Johnson, you're free to go as well. You have a blessed day. You have a blessed day as well, Mr. Lane.
Your Honor, I just have one, and it's very quick. Can we please call it so I can
What,
get home and elevate? Blake Hunter, it's on the trial.
Hunter. Oh, okay, here we go. Okay, this is cause number 23CCCR 2112, case of style of state of Texas versus Blake Aaron Hunter. Mr. Hunter, is that your full name?
Yes, sir.
How you doing, Mr. Hunter?
Good.
That's good. Now, Mr. Hunter, you're represented in your case by your attorney, Corey Crenshaw. Attorney Crenshaw, how are you doing?
I've been better, Your Honor.
Okay.
I will survive.
Okay, we pray that you get a lot better,
Thank you.
recover from whatever your illness is. Now, Miss,
Apparently I'm overweight, stress fracture.
wow. Wow. Okay, now, Mr. Crenshaw, what's your announcement in Mr. Hunter's
I
case?
believe the state is dismissing, Your Honor.
Oh,
That's correct, Your Honor.
oh, I
The
didn't.
dismissal was sent this morning.
Oh, okay,
I don't know if it's been sent to you as of yet.
okay, let's see.
The
Did y'all
state's
send-
having
did y'all-
pity on me in my diminished capacity.
I assure you that's not what it is. Judge.
I'm sure everybody
Oh,
else,
I do.
everybody will show up with crutches and everything, and the next time.
Yeah,
I think I deserve a hug for letting me go in front of all my people. That were here before me.
Well,
No,
if I could have
I've
had
been-
coffee in the core, I would have brought.
no, I've been keeping track. Actually, he's right in order. Yes. Yeah. So thank everybody else that came in after him.
Well, thank you, Judge. Y'all have a
Okay.
nice
You
day.
as well.
All right.
Better.
Yeah, we hope that you feel a lot better.
Yes,
Here we go.
perfect. You'll email it to me. Thank you.
All right, we'll see you later. Honor. Miss, let me ask you, Miss, your client, does he need to get a copy? It's gonna be off in about a
They said
they'd Minute.
email it to me.
You send it to me, Judge?
yeah.
I can go ahead and do it real quick.
Come on.
You just said.
Is he printing off? You got it? Oh, yeah, yeah. Ada McCaig? Court is in session in three cases, cause number 236CCR 0865, cause number M331910, and cause number M334212. All three cases is filed in the state of Texas versus Ada McCaig. Mr. McCaig, is that your full name? How you doing, Mr. McCaig?
Doing all right. How about yourself?
I'm doing fine, thanks for asking. Mr. McCaig, you're represented in your cases by your attorney Tom Kelly. Attorney Kelly, how are you doing?
Doing well, Judge. Thank you.
And Mr. Kelly, what is your announcements in Mr. McCaig's cases?
Judge, it's my understanding that probably in the pretty near future, there's going to be some felony cases that are coming to the DA's office. Like an opportunity.
Well, these cases been on a trial docket. One of the cases been on there for 865 days.
And
So I mean, if he just keeps accumulating cases, it's like, that's a way for continuous.
it's my understanding that the defense has a motion for continuance on file, and I believe it's defense's first.
No.
My other comment I'd like to make to the court. is that
Yes.
Aiden has just how many days? Well, 30 days. Completed the 30 days in a rehabilitation facility.
Okay.
So I'd like to ask for some time, Judge. There may be an opportunity for me to get to a resolution on everything at one time. So if I need to make a formal announcement today, it's not ready. Or to ask the court for continuance, whatever is customary.
Okay, he said that you had filed, you know, look
I
at it.
haven't. Yeah, we did. We did last week, Judge.
Okay. Um, okay, that's on this one. That's on all three. Let's see. Two. Okay, I see he had I guess he had a code appointed attorney, I guess, back in 22 and then 23 at a bond forfeiture.
Yes, sir. He never
showed
up.
And then, I guess you did a motion to substitute,
June or July of last year.
right? Yeah. Okay, give us a standard reset. Keep it on the trial packet.
Motion.
Hold on a minute. Hold on a minute. Yeah, we- So, okay. Maybe give them some bond conditions. Yeah, those bond conditions. Boy, that might, gave him something in 22. Okay. Okay. Mr. McKay, we gave you some, bond conditions back August 30 to 2022. Okay. One of the conditions is you're supposed to participate in the spin theft center and follow recommendations.
Yes, sir.
Okay, have you been participating? What happened?
They, were pushing meds on them. And my mom had even gone and checked in as a client and they were.
Okay, so,
push meds on her.
so you just
And so
decided to stop.
I checked it out.
So, but they didn't check you out.
I
Okay. But your,
Therapist multiple times.
okay, your attorney also said something that, you have a new case coming, you have, some more cases. One of the conditions of your bond is that the defendant is committing no offense against the laws of this state or any other state. You remember that?
Yes, sir.
Okay. So have a seat in the jury box. Yeah. Okay. We're gonna, yeah, we're gonna, find the bond is insufficient. Okay. Okay, we're gonna, he's gonna be taken into custody. Court is gonna hold that it bond is insufficient. And, we're gonna set him a new bond. Okay,
That one case, I don't know if I could get the approach and, because I had to be another court. It's okay.
Hmm?
I said, I only have one case, I just need to make an announcement on it real quick.
okay,
If it was okay, if I could,
okay, what's the
Is it-
case?
the cause number is 23 CCC R 1104, Foley Wood, or Foley Wayland Wood, I'm sorry. Like the last one on the announcement. This is, Foley Wayland Wood. Mr. Hubel, I think so.
Yeah. My wife-
Floyd Wayland Wood?
That's correct.
Okay. Okay, Mr. Wood, your full name is Floyd Wayland Wood? How you doing, Mr. Wood? I'm doing fine, thanks for asking. Now, Mr. Wood, you're representing the case by your attorney, J. Michael Reisinger. Mr. Reisinger, how are you doing?
I'm doing good, Your Honor. How about yourself?
That's good. Now, Mr. Reisinger, what's your announcement in Mr. Wood case?
Your Honor, the announcement on this case is we've just got entered into the portal so we can get all the discovery and everything. This is our first court appearance, so I'm asking the court for a reset. I'm not sure the court allows 60 days, but so I can go to discovery with him, we can get everything, and maybe we can work out a deal with the district attorney.
Okay. Give us a reset. October 21st.
Okay.
Okay, this case is reset to October 21st, 2024. Mr. Wood, once you get your reset from your attorney, you're free to go. You have a blessed session.
Thank you much.
You are. You're nice and
You too, Judge. Is that at 9 a.m.? I'm sorry.
yes, it's always at 9.
Okay, thank you.
Let's see, we have Mr. Okay, Miss Macy. Oh, she must not be here. Jacqueline Sevilla Hills.
There is no.
She is not here, Judge. I showed this to the prosecutor already. This is her son's positive COVID result test. He's
Okay,
about yay
okay,
big.
okay. So she couldn't appear by Zoom?
Well, I didn't tell her. I thought I was in court 3, and so I appeared in court 3. That's why I was late here. Well, I had a court case over there, and then I was talking to Judge Woods, and I'm saying, well, you know, I have another case here, Judge, and I showed him the
name?
sheet, the name and everything. He goes, and he looked at it, that's in court too, and I went, that was my fault. So I didn't tell her about Zoom because I thought I was in court 3. I don't know whether or not.
Give us maybe a 2-week reset.
So that was my fault, Judge. I apologize. I
He'll,
would have realized that it was court 2. I'd have told her.
okay, it was a September 4th. You.
4th works for me, Judge.
Okay, we reset it to September 4th. Okay, we hope that our son is, recovered, have a full and speedy recovery.
Thank you, Judge. So we have the excuse.
Yes, you can get your reset, your excuse. Mr. Parker,
I've just got 2 cases. I'm waiting on a tablet, Judge, on one.
Okay.
I have any tablets anywhere.
okay,
I think the court only has 2.
That's the state. I don't know if it's being just like-
you'd be 3 out there. 2,
One right there, we can go over it when I get done the other one.
okay,
And my other case is that we're asking to be reset with the felony.
who is,
That's Mr. Cardenas.
Jose Cardenas Mendoza,
Yeah.
is he here?
Yeah, he's here, right there.
Okay, have him come.
Yeah, he wasn't here when
He's been in the 257.
Okay, that's the case that you had 2 guys with the same name.
Well, I don't have, y'all have 2 guys with the same name. I only got one of them.
Yeah, okay. So, what are we doing on Mr. Cardenas Mendoza?
I'm asking to be reset with the felony. I'm not sure the date yet. They haven't given me the date yet, but we reset for him to look at discovery and I think we get worked out together.
Okay. Give us a reset date. Oh, it hadn't been, okay.
Right.
So we'll reset it with the felony and she'll check on the date.
Thank you.
All right, he's free to go.
Thank you.
You have a blessed day. Mr. Kurtz,
Morning, Judge.
good morning.
How are you?
I'm doing fine, and you? Let's see where you. A, B, C, D, E, F, G.
Mondays are a great day. Not Northfield. Monday's great. Stand by my previous statement.
Okay,
Track.
this is, okay, we have Michael J. Ford, he's on Zoom, I think, Holy Spirit, okay. Mr. Ford, would you please come forward? This is cause number 23CCCR 1402, case of style of state of Texas versus Michael J. Ford. Mr. Ford, is that your full name?
Yes, sir.
How you doing, Mr. Ford?
Pretty good.
Okay, that's good. Now, Mr. Gertz, what's your announcement in Mr. Ford's case?
We're just asking to reset it with his felony. We don't have a new date yet, but we expect to have one this afternoon.
Okay, the coordinator will check on a date. Stay in contact with your attorney, your bonds, when you're free to go, and you have a blessed day.
Thank
you. Is that it?
That's all.
Okay, Mr. Macon, we have Goldman.
Yes, Your Honor. He's a plea.
Yes,
He's going into custody today.
okay. Let's see. Okay. This is on, pretrial conference. Let's see. Which one is- Jefferson County Court at Law is in session in two cases. Their cause numbers M326042 and cause number M326044. Both cases are styled in the state of Texas versus Brian Joseph Goldman. Mr. Goldman, is that your full name?
Yes, sir.
Mr. Goldman, would you please raise your right hand? Mr. Goldman, do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Goldman, you may put your hand down. How are you doing, Mr. Goldman? That's good. Now, Mr. Goldman, you are represented in your cases by your attorney, Attorney James Macon. Attorney Macon, how are you doing?
Still here.
That's good. Now, Mr. Macon, do you waive a record in Mr. Goldman's case?
I do, Your Honor.
Okay, Mr. Goldman, in cause number M326044, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brian Joseph Goldman, on or about February 15th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Mr. Goldman, do you understand what you have been charged with? And to this charge, Mr. Goldman, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, Mr. Goldman, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there are two sets of initials. One set of initials is the initials of your attorney, and the other set of initials starts with a B. Is this your initials? And on page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Goldman, before you sign and initial these documents, did your attorney go over these documents with you? And did you read and understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Goldman, are you a citizen of the United States?
They don't make this one.
Any objections?
No objection, Your Honor.
No objections. State's exhibit number 1 will be admitted. Mr. Macon, you advised and counseled Mr. Goldman. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Goldman, your attorney, Mr. Macon, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Mr. Goldman, I will accept your plea of no contest. I will find that you are mentally competent to. Hold on.
Yeah.
Okay, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 10 days in the Jefferson County Jail, credit for 2, and with that, the state will also be dismissing the companion UCW case in 326042.
Oh,
Okay,
I filled out the paperwork for it.
now, that's 10 days for the
That's the
two.
agreement.
What's the court cost?
407.
They're dismissing these.
Now, Mr. Goldman, the state is offering that you serve 10 days in the Jefferson County Jail. You will be given credit for the 2 days that you have already served. The court cost in this case is $407. Will you be able to pay the $407 court cost?
Your Honor, we asked that it be taxed for the jail time.
Well, what I can do, he got 2 hours, he got
2 days credit.
2 days credit. We'll give him that 2 days credit. And that'll reduce it to $207.
Then he's got 8 more days to do in jail.
Well, you know, the sheriff, they control the time for jail. Okay,
Okay,
and so, he may or may not have 8 days to do.
well,
I mean, that's all I can say.
Yeah.
It may be 8 or less.
whatever he owes, he will take care of.
Okay, so you'll be able to pay the $207 court cost?
Yes.
Okay, now, we're gonna give him that 2 days credit toward the court
Yes,
cost. Yeah, well, I gave him the credit. I mean, yeah, he's entitled to get credit. Yeah,
Thank you.
okay, you're welcome. So now, Mr. Goldman, do you understand the state's offer? You think the state's offer in your case is fair and just? Do you accept the state's offer? Okay, now, Mr. Goldman, I'll follow, people are in agreement that you have in it, have with the state, and his jail time is starting today at or before 6 p.m., is that correct?
It's starting right now.
Right now. Okay, having,
Okay, it's done.
yeah, and then we have to redo his paperwork to give him the 2 days credit.
Oh, thank you.
And, oh, you know what? I forgot to do something. Mr. Goldman, would you come back up? I need to do something else. The state will be dismissing. Okay, Mr. Goldman, the state will be giving you, the state will be dismissing cause number M326042 for forfeiture of the weapon. I have before me a motion to forfeit the weapon to the Port Arthur Police Department. Do you recognize this motion? And is this your signature on the line as titled defendant?
Yes.
Now, before you sign this document, did your attorney go over this document with you?
Yes.
And did you understand everything that he went over?
Yes.
And is everything in this document true and correct?
Yes.
To the best of your knowledge? Mr. Goldman, I'll grant the motion to forfeit the weapon, in this case to the to the Port Arthur Police Department. Now, Mr. Goldman, do you have the paperwork for it?
No.
Okay. Just follow the bailiffs, have a seat, and you're gonna have to bring it back out.
Thank you.
Okay, you're welcome. You have a blessed day.
Jared Hardroder.
Jared Wesley Hargroder. This is cause number M333140, case of style of state of Texas versus Jared Wesley Hargroder. Mr. Hargroder, is that your full name? How are you doing, Mr. Hargroder?
Thank you.
I'm doing fine, thanks for asking. Mr. Hargroder, you're representing your case, your attorney James Macon. And attorney Macon, what is your announcement?
On Mr. Hardroder's
Yes.
case, Your Honor, we ask that it be set for trial. However, we will continue to arrive at a solution.
Okay, Could you give us a,
October 7th.
okay, this case reset October 7th for trial. Mr. Hargrove, you can get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go. You have a blessed day, and you have a blessed day as well, Mr. Macon.
Thank you, Your Honor. That finishes everything.
Okay.
I think it was really good.
Thank you.
Yeah.
Okay, court is in session and cause number M330398, case is styled state of Texas versus Willie Ray Guidry.
He's here. He must be on the side. I know he's here.
Okay,
The side is in the courtroom. That's mine too.
this is, what is he doing? Oh, okay, no, it's a guy, his bond was,
I didn't follow.
no, different case, his bond, the guy previously bond was, okay.
Thank you.
This is cause number M330398, case is styled state of Texas versus Willie Ray Guidry. Mr. Guidry, how are you doing? That's good, Mr. Guidry. You're representing your case by your attorney, Attorney Langston Adams. Attorney Adams, how are you doing?
Yes, who else?
And what is your announcement in Mr. Guidry's case? State,
State's ready.
okay? All right, y'all be back at 1:30. Okay, trial at 1:30 this afternoon.
1:30.
Okay. Next case is, cause number M332952, case is styled the state of Texas versus Andre J. Sias.
Your Honor, the state's going to be dismissed, submitting a dismissal on that case.
This case will be dismissed. Okay. Your case is gonna be, just have a seat. The state is gonna submit a dismissal. I'm gonna sign the dismissal. Once I sign the dismissal, you're free to go and you have a blessed day.
You too, sir. Thank you.
You are. Let's see, those are only two. Once we sign that dismissal, you'll be back, come back at 1:30 now. Yolanda. Oh, this is cause number 24CCCR 0260, case of style of state of Texas versus Anthony Joseph Williams Sr. Mr. Williams is on Zoom. Mr. Williams, you can take your mic off of mute.
Yes, sir, Your Honor.
Okay, now, Mr. Williams, earlier, you had a hoodie on. I told you need to take your hoodie off. Now you have a wave cap on. You need to take that off too, because you're in court. All right.
My apologies, Your Honor.
Okay, you're welcome. Now, Mr. Williams, how are you doing?
I'm doing well. How are you doing, Your Honor?
I'm doing fine. Thanks for asking, Mr. Williams. You're represented by your attorney, Mr. Mel Shalander, who's present in court. Mr. Shalander, how are you doing?
When I'm not tied up, I'm doing great.
Oh. Okay. Yeah.
Literally.
Yeah, I know. That's literally, yeah. Mr. Shillander, what is your announcement in Mr. Williams' case?
Yeah, it's gonna be a plea. If we could reset it to September 26th.
September 26th?
Mr. Williams lives in California, and I can get him back here on that day. if we-
Okay. We're gonna reset your case for September 26th, 2024 for a plea. Stay in contact with your attorney and your bondsman. They will be given notice of your resets. You're free to go. Thanks for being patient with us, and you have a blessed day.
You too, Your Honor.
Okay.
I'll be in touch with you. Anthony.
All right, thank you. All right,
All
Mr.
right.
Slander.
And Mr. Shillander, once you get your reset, you're free to go.
Thank you.
You have a blessed day. Senior Samuel? Gallego?
Gallego.
Gallego?
Gallego.
Gallego, okay.
We're gonna teach you Spanish one day, Judge.
Oh, let me send this back to you.
Okay.
Okay, I just sent it back to you. Okay. There you go. Yeah. Hmm? Okay. Yeah. Okay, let's see. Gallego. Let me see what documents, you know. Oh, no, that's Tillman. Oh, Sam. Gallego, Gallego. Okay, this is cause number 236 1292. Case is style the state of Texas versus Samuel A. Vallejo. Please come forward. He just sent what's his name? Is that Size?
Yes.
Okay, Mr. Size, I'm signing the dismissal now. I just sent it. Okay,
Before we get Mr. Gallego, could I make my announcement on the two gentlemen that are on Zoom?
Is that Michael C. Tillman?
Mr. Michael Tillman, yes. On Mr. Tillman, we've reached some agreement. And
We just need to.
they're gonna call that into it's a class C.
Okay, so JP reduction?
Yes.
Yes, sir.
Okay, so we're gonna reset it. How much time will he need to take care of that?
I mean, as soon as however long it takes them to call it in, we'll have it done, Your Honor.
Okay, would I just reset it for a week?
That'll be fine. I think we can get it done, yeah.
Okay, Mr. Tillman, your case will be reset for a week. The state will refile this case to be a Class C misdemeanor. Once you take care of that, this case will be dismissed. Is that correct?
That's correct.
Okay, so Mr. Tillman, thanks for being patient with us. You're free to go and you have a blessed day. Stay in contact with your attorney.
Thank you, Your Honor.
Okay. And that's 1 week. That's
Michael Tillman.
that'll be on the 26th.
Oh, yeah.
Yeah. And if it gets done before that, they'll just
We'll let
dismiss
you
it.
know. Yeah.
Okay. Okay, you're free to go, Mr. Tillman.
Thanks, sir.
You're welcome. Now you have,
And then Mr. Manuel Sanchez, he's also on Zoom.
okay, let me. Okay. Manuel Sanchez Oliva,
Yes, Sí.
how are you doing?
Good.
That's good. Now, Mr. Sanchez Oliva, you're represented by your attorney, Attorney Jared Gilthorpe. Mr. Gilthorpe, what's your announcement?
Judge, we had that placed on a trial, for a trial docket.
Judge, when we do place it for a trial docket, I do want to know that the state will likely need a translator, so.
Yeah, I think they filed,
That's
well,
correct, Judge. I've already filed a motion for an interpreter.
yeah, he filed the motion for, one for him. Yeah,
And state's witness would also likely need one, so if we could potentially get a special setting in this case.
oh, you're talking about a special setting, so we, when we set it for trial, it'll be going. We may, okay. Yeah, we'll give you a special setting. Now, what we need to do, we can either get with you and the prosecutor to coordinate the calendars,
Okay.
and then to give us that special setting. So at this time, the case will be reset for trial. We won't be able to give you a trial date right now.
Would you like me to email Trina about and have a three-way email with Mr. Hubel?
That's fine.
myself, and Trina?
That's fine. Yeah,
Oh.
everybody, yeah,
Everybody, yeah.
yeah.
I can
Okay.
do that, Judge.
All right, so Mr. Sanchez Oliva, your case is gonna be reset for trial. Stay in contact with your attorney. You're free to go, and you have a blessed day.
Okay. Thank you.
You're welcome.
Okay.
Okay. Oh. Okay, now this is cause number 23CCCR 1292. Case of style of state of Texas versus Samuel A. Gallego Vallejo.
Gallego.
Vallejo.
Gallego.
Vallejo. Okay, how are you doing, Mr. Vallejo? Mr. Vallejo, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? So he speaks Spanish?
He speaks some English, and I'm assisting him with Spanish.
Okay, you may put your hand out. And Mr. Gilthorpe, you just raise your right hand. You swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Your Honor.
Okay, you may put your hand down. Ask, Mr. Vallejo, how he's doing.
Good.
He's doing good? That's good. Now, Mr. Vallejo, well, Mr. Gilthorpe, do you waive a record
Yes,
in
Your
Mr. Vallejo's case? Mr.
Yes.
Vallejo, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Samuel, say Gallego Vallejo, on or about December 3rd of 2022, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the class A misdemeanor offense of driving while intoxicated. Okay, it would be driving intoxicated second. Even though the information, it reads as a DWI first, the body reads as a DWI second.
Your Honor, the agreement we reached was for a DWI first.
So you abandoning us.
That's correct, Your Honor.
I know it came out as D, that's what I'm saying. whoever filed it in the computer with the state, they punched it in as a DWI first, even though the information reads as a DWI second. And I think what she has to do is show on the paperwork that it was reduced from a first, I mean, from a DWI second to DWI first. She's gonna have to call the district attorney's office for them to change the coding.
Okay,
So that just is gonna take a few minutes.
we'll wait, Your Honor.
Yeah, okay. All right. And the paperwork right here is still good. They have state already in what abandons enhancement. I'm gonna send it back to her. The information, the body of the information is the DWI second. But it's filed as a DWI. It's coded as a DWI first. Yes, coded as a DWI first.
And we're playing it as a first.
Right. Right. Pettaway, your full name is Chelsea Nicole Pettaway?
Yes, sir.
How are you doing?
Doing okay.
All right. Now, I see your case is on the jury trial docket.
No, it says to hire, right?
I see that, but I'm just wondering why it's on the jury trial docket. What she wrote. Jury trial. You were in court on the April the 4th. And on that day. Said you was gonna hire Wright Kim. I don't know why it appeared on the jury
I had
trial.
already hired Mike Kibler, and he was in another, court, he ended up showing up, and I believe we set the trial.
Oh,
But
he
he's
set it
hired.
for trial.
Yeah, yeah, he's hired.
And he's on vacation this month.
Okay, I will not verify that.
Okay, and he didn't send a letter of representation informing the court that, could you check and see if there's no letter of rep?
There's an issue with that same thing last time as well. But
Right.
He ended up coming in, and I guess said he was gonna file something with the court or something, I'm not sure. But he is hired, but he did not tell me that he was on vacation.
Okay, what we need to do is reset this just reset it for about 2 weeks, put it on the announcement docket. See if we can get Mr. You're gonna have to contact Mr. Kimball's office and let them know that we don't have a letter of representation. Yeah, the letter is just informing the court that he has been hired to represent you. Oh, wow. Okay. Just give her a reset. Do you work?
I'm on a medical leave at the moment. I work for Dollar General. I'm getting gallbladder surgery on the 29th.
Okay, well, hope you have a successful surgery.
Thank you very much.
Okay, on the 29th.
This month.
Oh. We got to, let's give a standard reset because it's gonna be 2 weeks. You just gonna be getting out the hospital.
Right.
Yeah, just give a standard reset. How long, let me ask you this here, recovery time. Did they tell
It
you?
will vary 4 to 6 weeks is what I was told.
Well, give a 2-month reset, but you need to get in contact with Wright Kimball to tell him to get the letter of representation. Okay. She's gonna get you reset. Once you get your reset, you're free to go. You have a good day.
Yeah.
Okay. You set it back, you got it ready? You have to get in contact with Cornelius. Is the paperwork?
I'm having an issue like we had last week, but I think I know it. Once you do that, it lets us up with your name.
Yeah, but you just caught it. It's the layoff.
Judge, I'm gonna do that, Helen.
Who is her attorney?
That was St. Kelly's last.
Oh, it is? What, okay, that's Kaylin? Oh. Okay. This is cause number 23CCCR 0466. Case of style of state of Texas versus Kaylin Janae Beaver. Ms. Beaver is appearing via Zoom. Ms. Beaver, how are you doing?
I'm good, thank you.
Okay, now Ms. Beaver is represented in her case by attorney Tom Kelly. Attorney Kelly, what's your announcement in Ms. Beaver's case?
Judge, Ms. Beaver has advised me this morning that she's under the weather, and I think that the court can both see that and hear that. So if you'd like for her to expound on that.
No, she doesn't need to tell her we're on YouTube. She don't need to tell her we're a medical condition. We have a note here saying that she was appeared by Zoom. She contacted, I think, the court coordinator. And so now you want to keep this on the trial docket? On a trial docket. Okay. Okay, let's give her a standard reset. September 30th. Okay, Miss Beaver, Your case
Yes,
will
sir.
be reset to September 30th, 2024 for trial. On that day, you need to, like today, you just have to appear in person. Court will be praying that you have a full and speedy recovery from your illness. You're free to go, and you have a blessed day. Stay in contact with your attorney and your bondsman.
Yes, sir. Thank you. You too.
Okay, you're
Have a
welcome.
good day.
You're welcome. And Mr. Kelly, you can get your reset. Once you get your reset, you're free to go and you have a blessed day.
Unless the court will allow me to, approach again on Mr. McKay, Judge, that's all I have today.
Oh, okay. Okay, who else we have? Gilthorpe?
Yeah. Me, but I'm okay. When I'm gonna put a word in.
Gilthorpe. Okay, Gilthorpe. Um, Oh, here we go. I think that's it. Oh, here it is. Okay, let me go back to you. You're reading the information. You're gonna, I know you wrote it on there, you're probably gonna. No, you already, it's in the right box. Now, Mr. Vallejo, I have before me. Let me get back to that information. Okay. Mr. Vallejo, I have before me an information sheet that was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, on or about December 3rd of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the class A misdemeanor offense, driving while intoxicated. Second, this information further alleges that prior to the commission of this offense, on April 3rd of 2012, in cause number 288635 in the County Court at Law number 3 of Jefferson County, Texas, that you were convicted of operating, well, that you was convicted of an offense relating to operating of a motor vehicle while intoxicated. Okay, now the state is abandoning that enhancement paragraph. Is that correct, state?
That's correct.
And what that means is you will not be charged with a class A driving while intoxicated misdemeanor. You will be charged with a class B misdemeanor driving while intoxicated, which is a lesser included offense. Do you understand? And so to the class B misdemeanor offense of driving while intoxicated, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes,
And are you pleading no contest because you do not wish to fight or contest the charges?
yes, or no, but in the way it's phrased, it would be no, he is not protesting the charge.
Okay, let me ask you briefly, Scott. Now, you're pleading no contest because you do not wish to fight or contest the charges, is that correct?
Yes, I do not want to fight it.
Okay. Now, are you pleading no contest freely and voluntarily?
For my own, wishes.
That's your wishes, okay. Now, Mr. Vallejo, I have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes,
On page 2 of this same document, there are a set of initials, SG, on the line that is titled Nola Contendere, which means no contest. Did you place your initials on this line?
yes.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes,
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
yes,
And is this your signature on the line that's titled Defendant?
yes, yes,
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
yes, I understand.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, I understand.
I have another document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Okay. Yes,
Now, Mr. Vallejo, going back to the first document on this tablet, there's a paragraph that is titled Citizenship. Are you a citizen of the United States?
no. No.
This paragraph states that if you are not a citizen of the United States, a plea of guilty or nolle contendere may result in deportation, exclusion from admission, and denial of naturalization under federal law. Do you understand?
Yes, I understand.
Okay, could he put his initials on that paragraph? Now, he needs to fill out one of these forms.
He's from Columbia, Your Honor.
Columbia?
Yeah.
Okay. It's not a mandatory notification. I could give it to him in Spanish. There you go. He'll fill out the top portion. Grievance. Okay. Now, Mr. Vallejo, I have before me a document that is titled Spanish for all foreign nationals except those from mandatory notification countries. Do you recognize this document?
Yes.
And is this your signature on this document?
Yes.
Now, before you sign this document, which is in Spanish, did your attorney go over this document with you in Spanish?
Yes.
And did you read and understand everything that your attorney went over? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
And to the question, do you want us to notify your consular officers? At this time, you circled no, is that correct?
Yes.
Now, Mr. Gilthorpe, you advised and counseled Mr. Vallejo. Did you advise him as to the consequences of pleading guilty and no contest by virtue of him not being a citizen of the United States, and that's pursuant to the case of Padilla versus Kentucky?
Yes, Your Honor.
Okay. Now, Mr. Vallejo, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you in Spanish? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Yeah, for stage one.
Any objections?
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Gilthorpe, you've advised and counseled Mr. Vallejo. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Vallejo, your attorney, Mr. Gilthorpe, has advised and counseled you. Are you satisfied with his services?
Yes, Your Honor.
Mr. Vallejo, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement? And what is the agreement?
For defendant's plea of no contest, the state has offered 180 days probated over 15 months with a $750 fine, 60 hours community service, the installation and maintaining of an airlock device, and DWI first stand conditions of probation.
What is his court cost? Okay, Mr. Vallejo, the state is offering that you serve 180 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 15 months. During the 15-month probationary period, you'll be required to pay a fine of $750, a DWI conviction fine of $100, court costs of $392, a probation fee of $60 a month, a urinalysis fee of $15 a month, a reimbursement fee of $15. You will also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you'll be required to pay each month, is $170. Will you be able to pay the $170 each month? Okay. You will also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms of DWI probation. Mr. Vallejo, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Okay, Mr. Vallejo, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Vallejo, this will conclude your case. Please stand in front of the court coordinator and follow her directions. And once you finish following her directions, you'll be free to go. And you have a blessed day.
Thank you, Judge.
You're welcome. Ricky Renee Hartfield. Ms. Hartfield, your full name is Ricky Renee Hartfield?
Hartford.
Hartford, okay. Ms. Hartford, excuse me for mispronouncing your name. Ms. Hartford, would you please raise your right hand? Ms. Hartford, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hartford, you may put your hand down. How are you doing?
Good, how are you?
I'm doing fine, thanks for asking, Ms. Hartford. You're represented in your case by your attorney, Alan Parker. Attorney Parker, how are you doing?
Good, Judge, thanks.
Mr. Parker, do you waive a record in Ms. Hartford's case?
We did.
Ms. Hartford, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet alleges that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.515 or more. State, are you abandoning the enhancement prayer? No.
No, we're not.
Okay, now, Ms. Harford. To the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more, which alleges that on or about May 18th of 2023.
Your Honor, I believe we would have to.
Yes.
Okay, I asked was the, okay. Okay, because somebody said no when I asked
It
was
was-
the abandoning.
It was,
So you are abandoning the enhancement paragraph?
That's correct, Your Honor.
Okay,
I need to check B and not A
yeah,
on there.
okay, hold on a minute. Yeah, that's not a problem. He can, let me see.
The A.
Because I know I saw something was a Class A, and then I looked here and I saw it was a, well, saw it was a B. That's what kind of threw me off.
I would need to make changes too.
Let's set that. You want down there. That it? You good?
Okay. Now, Ms. Harper. The state is abandoning the enhancement program. What that means is, instead of being charged with a Class A misdemeanor offense, DWI, you will be charged with a Class B misdemeanor, DWI, which is a lesser or lower offense. Do you understand? Okay. Now, to the Class B misdemeanor offense of driving while intoxicated, which occurred on or about May 18 of 2023 while you're operating a motor vehicle in a public place in Jefferson County, Texas. How do you plead guilty, not guilty, or no contest?
No.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? I also have a document before me that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there are a set of initials on the line next to a box that's checked NOLA contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Hartford, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Hartford, are you a citizen of the United States?
Zero for states one.
Any objections? No objections. State's exhibit number 1 will be admitted. Mr. Parker, you've advised and counseled Ms. Hartford. Is there any evidence that she is currently mentally incompetent to stand trial?
No, you're right.
Ms. Hartford, your attorney, Mr. Parker, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Ms. Hartford, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement is to 1 year deferred probation with a $500 fine, 60 hours community service. DWI first standard conditions of probation and the installation of things on your left device.
What is the court cost? 3.2. Okay, Ms. Harford, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You will also be required to pay a DPS conviction fine of $100. You'll also be required to pay a probation fee of $60 a month, or your analysis fee of $15 a month, a reimbursement fee of $15. You'll also be required to pay Jefferson County $125 on the day of the plea for the DWI education and initial evaluation fee. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $173 a month. Will you be able to pay the $173 each month? You will also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and condition of DWI probation. Ms. Harford, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Ms. Harford, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Harford, if you successfully complete this probationary period, this case will be dismissed. It would not result in conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Harford, please stand next to the bailiff, follow her direction. Once you finish following her direction, you're free to go. You have a blessed day. And Mr. Parker, you're free to go as well, and you have a blessed day.
Thank you.
Okay, Mr. Johns? Yes.
Thomas?
Yes. This is cause number M333112, case of style of state of Texas versus Jericho Gerard Thomas. Mr. Thomas, is that your full name? Mr. Thomas, how are you doing?
Good.
You doing good? Oh, that's fine. Now, Mr. Thomas, you're represented in your case by your attorney, Attorney Theodore Jones Jr., Attorney Johns. How are you doing?
Pretty good, you know.
Mr. Johns, what is your announcement in Mr. Thomas's case?
Well, we have a case, actually two cases in the drug court system. And last time we were here, they, a DWI third, which we knew he had been arrested for, we had never got the charging information for, and they presented it the last time we were here. There was a problem with the discovery. I guess when they transferred 1 million documents over there, whatever reason, discovery didn't open up on that portal. And I talked to Ms. Porter, the DA, and she communicated with Karen, and they made the discovery available to us Thursday of this week.
Oh,
Okay.
okay.
So as far as we're concerned in that particular court, okay, we're still working on plea bargain agreements. This particular court, okay, which we think we have a solid case for dismissal, someone will look at the case and would dismiss, they would dismiss the case. We had it set for trial. The defendants are out of town. And actually it should have been a civil case filed in the first place. I won't go into details of the case, but I'm pretty certain if someone in the prosecutor's office really look at this case fairly, they'll dismiss this case.
So what's your announcement?
Well, it's the same as last time, we said for trial.
Okay, last time, because it's on the pretrial docket.
Well, we said for trial, but you moved to the pretrial docket waiting on
Oh.
the cases.
Okay, so we're gonna set this on.
Actually, it was set for a trial docket, but we didn't have a jury that week when we came, I think, a month ago. The last time we were here, we didn't have a jury. So you reset it, moved it from the trial docket to the pretrial.
Okay, so we're gonna put it back on the trial docket? Y'all wanna,
I would think so. If there's, I'll be honest with you, I honestly believe if someone look at this case, when the prosecutor's office look at it fairly, they would dismiss the case.
And just to represent to the court, someone has in fact looked at this case and the decision to dismiss this case has not been made.
okay,
So,
so we're gonna reset it and put it on the trial docket.
Yes, sir.
Okay, give us a reset date. Okay, this case reset October 7th, 2024. Ms. Thomas, you're gonna get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go. You have a blessed day. And Mr. Jones, you'll be free to go as well. You have a
Thank
blessed
you.
day. Nastasia Carbon.
Since counsel has brought to the state's attention that Ms. Corbin intends to waive her right to discovery, I don't know if there's a document that we need to send. That's,
They usually have it on the,
it's,
when the person is pro se. I know it's on that one.
yeah, but it's not typically on the standard defense attorney.
But there's some. Miss Mosby. Yes, sir.
the finding that the bond was insufficient. I'm most certainly aware of the court's concern that there was a new offense committed, and I don't want to dance
Yeah, okay.
around what the condition says that do not commit an offense and argue, well, until he's convicted, he hasn't committed an offense. I don't want to play gymnastics with the court. I understand also the court's concern about the spindle top condition, but again, I would mention to the court that Aiden just completed 30 days in a rehabilitation facility. As a person and as his lawyer and as an officer of the court, he looks better than I've seen him since I've known him. I would ask the court to take that into consideration. I also think there could potentially be a resolution here. But what I'm asking for is that the bond not be revoked so that it doesn't potentially hinder the progress he's made over the course of the last month in terms of improving himself.
State, yeah, but
In regards to the new offense, it doesn't appear that our office has received any offense yet. I'm not sure if it's from our county or another county. So I can't really speak to that. But the defense had submitted a motion for continuance in this case, and I had already been unopposed to that continuance. So I'm not really of the position that necessary at this point, especially considering the fact that I can't see that new offense. That was the driving reason why he was taken on. I can't see it on my side yet.
yeah, okay. That's one reason, but the other one, he was required to attend the Spinatop program and follow the recommendations.
And on that reason, the state would defer to the court's judgment.
Yeah, well, at this time, the court is just to take it under advisement. At this time, take another look at it. Okay. Okay. All right.
I'll check back in with the court if that's okay.
Okay, that's fine.
Okay, thank you, Jim.
Okay. Okay. Did you, were you able to put that language?
I
Oh.
mistreated it.
Oh, okay. She has two of them, huh?
I ain't gonna go across the way. Oh, you want to go to the woods?
She has two of them. I'm gonna send both of them to you. Okay. I just sent both of those cases back to you. What else do we have? Okay. Ms. Carbon, your full name is Nastasia C. Carbon? Okay, Ms. Carbon, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Carbon, you may put your hand down. How are you doing, Ms. Carbon? That's good. Ms. Carbon, you're represented in your case, or you're in cases by your attorney, Peter Doyle. Attorney Doyle, how are you doing?
I'm doing pretty good, Judge.
That's good. Mr. Doyle, do you waive a record in Ms. Carbon cases?
Yes, sir, we do.
Ms. Carbon, in cause number 24 CCCR 0642, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nastasia C. Carbon, on or about February 15th of 2024, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of failed to identify fugitives with intent to give false information. Ms. Carbon, do you understand what you have been charged with? You have to speak up. And to this charge, Ms. Carbon, how do you plead? Guilty, not guilty, or no contest? No contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And Ms. Carbon, are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, Ms. Carbon, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked nolo contendere. And then another set of initials on next to a statement that states that you do not request discovery of the evidence and you waive your right to request discovery in this case, and you choose to enter a plea of guilty and no contest. Did you place your initials on this document? You have to speak up.
Yes, sir.
All right. Now, Ms. Carter, I also have before me on page 3 of the same document, a signature above the line that is titled defendant. Is this your signature?
Yes.
On the next document, that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Ms. Carbon, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Dole, go over these documents with you?
Yes, sir.
And did you read and understand everything that Mr. Dole went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Carbon, are you a citizen of the United States?
Yes, sir.
Stay up for 6-1.
Any objections?
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Dole, you have advised and counseled Ms. Carbon. Is there any evidence that she is currently mentally incompetent to stand trial?
None, Judge.
Ms. Carbon, your attorney, Mr. Dole, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Ms. Carbon, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
Is this the new cause number or the old cause number?
The new cause number 24 CCCR 0642.
In that case, the agreement is to 12 days time served for cause tax and retired.
Ms. Carbon, the state is offering that you serve 12 days in the Jefferson County Jail. You will be given credit for the time that you've already served. And that simply means that you will not have to serve any more time in jail on this case because you've already served 12 days in jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Carmen, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Could you send me her second case back? And Ms. Corbin, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Corbin, we will move to your next case. And your next case is cause number M333692. And in this case, Ms. Corbin, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Nastasia C. Corbin, on or about July 17th of 2022, this is the other case, M333692. And in this information, it alleges that you, Nastasia C. Corbin, on or about July 17th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Ms. Corbin, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Corbin, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Corbin, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are two sets of initials. The first set of initials are on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
Second set of initials are on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
Now, on page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
And State, do you have I'd like to offer State's Exhibit Number 1?
Yes, Your Honor.
No objection.
No objection. State's Exhibit Number 1 will be admitted. Now, Ms. Corbin, your attorney, Mr. Dahl, is advising counsel to you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Ms. Dahl, you've advised and counseled Ms. Corbin. Is there any evidence that she is currently mentally incompetent to stand trial?
None, Your Honor.
Ms. Corbin, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
The agreement's to 33 days, time served, court cost tax retired.
Ms. Corbin, state is offering that you serve 33 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 33 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already spent in jail. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Corbin, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Ms. Carbon, I'll follow plea bargaining agreements that you have entered into with the state. Ms. Carbon, Please stand next to the bailiff, follow her directions. Once you follow her directions, you'll be free to go. Now, Ms. Carver, if you do not have anything else holding you in jail, you should be getting out of jail today. You have a felony date in the computer? Okay. September 30th? Okay, we're gonna reset it to September 30th. Once you get your resets, you free to go. He just had one case. Okay. Oh. No yawning in the courtroom.
Sorry, be at home.
Yeah. Okay, he's in custody. Okay, now we have Mr. Who we have next? Mr. Jeffers? Mr. Jeffers? Who is this? Is it, yeah, David Torres? Okay. Mr. Torres, your full name is David Torres Jr.?
Yes, sir.
Mr. Torres, would you please raise your right hand? Mr. Torres, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Tell the truth.
Okay, you may put your hand down. How are you doing, Mr. Torres? That's good. Mr. Torres, you're represented in your cases by your attorney, Attorney Benjamin Jeffers. Attorney Jeffers, how are you doing?
Doing well, Your Honor, thank you.
Mr. Jeffers, do you waive a record in Mr. Torres' cases?
Yes, sir.
Mr. Torres, in cause number 24 CCCR 1128. I have before me. Somebody's up.
The bailiff's still on.
Okay. Okay, in cause number 24 CCCR 1128. I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Torres, it alleges that you, David Torres Jr., on or about March 11th of 2023, excuse me, March 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal mischief. Mr. Torres, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, Mr. Torres, how do you plead guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
No contest.
Now, Mr. Torres, I also have before me a document that is titled Misdemeanor Plea Admonishments, also labeled as states Exhibit 1. Do you recognize this document? You have to speak up.
Yes, Your Honor.
On page 2 of the same document, there are a set of initials on a line next to boxes check nolo contendere. Did you place your initials on this document?
Yes, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Sure.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement?
Yes, Your Honor.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement?
Yes.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
Mr. Torres, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, Your Honor.
And did you read and understand everything in these documents?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Torres, are you a citizen of the United States?
Yes, Your Honor.
State offer states 1.
Any objections?
No objection.
No objection. States Exhibit number 1 will be admitted. Mr. Jeffries, you have advised and counseled Mr. Torres. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Torres, your attorney, Mr. Jeffries, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Mr. Torres, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 160 days in the Jefferson County Jail, credit for 160 days to tax and retire court cost. This will also run concurrent with clause 24 CCCR 1129, and the state will also be dismissing the companion case 23 CCCR 1594.
Let me dismiss the next. Mr. Torres, the state will be, well, in this case, Mr. Torres, the state is offering that you serve 160 days in Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail on this case because you've already served 160 days in Jefferson County Jail. Therefore, you give them credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. This case will run concurrent with the companion case, cause number 24 CCCR 1129. And the state will be dismissing cause number 24 CCCR 1594.
Your Honor, that should read 23 CCCR 1594.
1594, what else?
You said 24, it should be 2.
Okay, 23 CCCR 1594 will be dismissed. Now, Mr. Torres, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Torres, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Torres, we'll move to your next case. And your next case is cause number 24 CCCR 1129. And in this case, I have before me an information that alleges that on or about March 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting transportation. Mr. Torres, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, Mr. Torres, how do you plead? Guilty? Not guilty?
Yes.
No contest. Now, are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Torres, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments, which is also State's Exhibit number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's I guess a signature on a line next to a box that's checked nolo contendere, which means no contest. Did you place your signature on this document?
Yes, Your Honor.
And on page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. Do you understand that statement?
Yes, Your Honor.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
And Mr. Torres, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, Your Honor.
And did you read and understand everything that your attorney went over?
Yes, Your Honor.
And is everything in these documents true and correct
Yes, Your
to
Honor.
the best of your knowledge?
Yes, Your Honor.
State offer states 1.
No objection.
No objection. State's Exhibit number 1 will be admitted. And Mr. Torres, your attorney, Mr. Jeffries has advised and counseled you in this case. Are you satisfied with his services in this case?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
And Mr. Jeffries, you've advised and counseled Mr. Torres. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Torres, I will accept your plea of no contest. I will find that you're mentally incompetent to stand trial. I will also find that your plea and waiver is freely voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State the will of plea bargain agreement.
Yes, Your Honor.
And what is the
In
agreement?
exchange for defendant's plea, the state's offering 160 days in the Jefferson County Jail, credit for 160 days. This is to run concurrent with clause 24 CCCR 1128, and the state will be dismissing clause 23 CCCR 1594.
Okay, Mr. Torres, the state is offering that you serve 160 days in Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail because you've already served 160 days. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because you've already paid. The time that you spent in jail has already paid off your court costs. This case will run concurrent with cause number 24 CCCR 1128, and the state will be dismissing cause number 23 CCCR 1594. Mr. Torres, do you understand the state's offer?
Yes, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Torres, I'll follow the pre-warning agreement that you have entered into with the state. Now, Mr. Torres, you're gonna stand next to the bailiff, follow her direction. Once you finish following her directions, you can follow her and you have a blessed day. And Mr. Jeffrey, this is your last case.
Correct.
You're free to go and you have a blessed day.
Thank you, Your Honor.
You are. Okay. Malcolm Buckley. Court is in session of cause numbers 23 CCCR 2444 and cause number 23 CCCR 2445. Both cases are styled the state of Texas versus Malcolm Buckley. Ms. Buckley, Mr. Buckley, is that your full name?
Yes, sir.
How are you doing, Mr. Buckley?
I'm good. How about you?
I'm doing fine. Thanks for asking. Mr. Buckley, you're represented in your cases by the attorney Bruce Smith. Attorney Smith, how are you doing?
I'm fine, how are you?
I'm doing fine. Thanks for asking. Mr. Smith, what is your announcement in Mr. Buckley's cases?
Yes, Your Honor, we just left the drug court and the court has reset his felony, what they call a normal resetting, and I don't know the exact date. We're asking that this be carried into that date.
Okay. Now, let's see, Buckley. Okay, now, Mr. Buckley, I would imagine these cases came out of the same criminal episode?
We can run that, Your Honor. What they do know is that there is an offer from the felony prosecutor that contemplates all these cases.
Oh, yeah, okay.
No, the felony is an MTRP.
Oh, the felony is a motion to revoke probations. Okay, probably because of these offenses may have been alleged in the motion to revoke probation. Okay, so we're gonna. Okay, so what y'all, you said the case is reset?
Yes, Your Honor.
What did they reset the felony cases for? Did they reset it for like a hearing or
No.
announcement or something? Okay, we're gonna reset the August 26th. Okay. Oh, it's reset to August 26th? Okay, your felony case has been reset to August 26th. So we're gonna reset these cases August 26th as well. And Mr. Buckley, your attorney gonna get your recess. Once you get your recess from your attorney, you're free to go. And you have a blessed day, and you have a blessed day as well, Mr. Smith.
Reset?
Yeah, you should be resetting, what's his, Roebuck cases, yeah. Because I see his client's still here.
Both of them.
You heard? Yeah, I think I mentioned it a while. We're just gonna check to see on Mr. Roebuck. You working on the plea? No, she's waiting on, she's doing the paperwork.
Oh, on Edwards, he is in custody in Chambers.
Kelly, oh, okay. Kelly thought he was in drug court.
Boy Wood, on page 6 of the,
Which one you sent? Floyd Wood was reset to October 21st. It needed some discovery. You sent which to me? Mendoza?
yeah,
Mr. Mendoza? Ricardo Martinez Mendoza? This is cause number 23CCCR 2206, case of style of state of Texas versus Ricardo Martinez Mendoza. Mr. Martinez Mendoza, is that your full name?
Yes, sir.
Would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down. How are you doing, Mr. Ricardo? You doing better?
Yeah.
Okay, Mr. Mendoza, you're represented in your case by your attorney, William Marcus Wilkerson. Mr. Wilkerson, how are you doing?
Recovered, Judge.
Well, that's good. Glad to hear that. Now, Mr. Wilkerson, do you waive a record in Mr. Martinez Mendoza's case?
We do, Judge.
Mr. Martinez Mendoza, I have before me a document on my computer that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Mr. Martinez Mendoza, it alleges that you, Ricardo Martinez Mendoza, on or about September 19th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of violation of protective order. Mr. Mendoza, do you understand what you have been charged with?
Sure.
And to this charge, Mr. Mendoza, how do you plead? Guilty, not guilty, or no contest? Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Now, Mr. Mendoza, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit 1. This document is on the tablet. Do you recognize this document? On page 2 of the same document, there are a set of initials on a line next to a box that's checked no contendere, which means no contest. Would you place your initials on this document?
Yeah.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document is titled Trial Court Certification, a defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargaining case and you have no right of appeal. You understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
I do.
And is this your signature on the line that's titled Defendant? Now, Mr. Martinez Mendoza, before you signed and initial all of these documents that I just showed you, Did your attorney, Mr. Wilkerson, go over these documents with you?
Yes, sir.
And did you read and understand everything that Mr. Wilkerson went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
They are.
Mr. Martinez Mendoza, are you a citizen of the United States?
Stay up for 6-1.
Any objections?
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Wilkerson, you've advised and counseled Mr. Martinez Mendoza. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
And Mr. Martinez Mendoza, your attorney, Mr. Wilkerson, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes.
Mr. Martinez Mendoza, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement is to 90 days probate over 1 year, with a $1,000 fine and community service waived in this case. There's also to be no contact with the complaining witness outside of necessary custody arrangements.
What is this court cost? Ms. Wilkerson, you were appointed,
No, Your Honor. I was retained.
retained. Okay. Okay, now, Mr. Martinez Mendoza, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $1,000 plus court costs of $277. You will also be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $199 a month. Will you be able to pay the $199 each month?
Yes, sir.
You will also be required, well, you will not be required to pay, not to pay, but perform any community service because the state is waiving the community service in this case. You cannot have any contact with Kristen Ashley Ellis outside of the custody arrangements. Is that correct? And you would adhere to the other standard terms and conditions of probation. Do you understand?
Sure.
Now, Mr. Martinez Mendoza, do you understand the state's offer?
I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
You accept the state's offer.
Yes, sir.
Mr. Martinez Mendoza, I'll follow the people who are in agreement that you have entered into with the state. Now, Mr. Martinez Mendoza, this will conclude your case. You're going to follow the directions of the bailiff Once you finish following her directions, you'll be free to go and you have a blessed day. Now, before you follow the directions of the bailiffs, I need to give you a document. And that's before you. That is, I'm going to go over this document, which is titled Model Written Admonition on Ineligibility to Possess Firearm Ammunition. Do you see that title?
I do.
Okay. And it reads as follows. In accordance with the Texas Administrative Code, section 176.1, the court hereby admonishes you of the following. Number one, you are, by entry of order or judgment, ineligible under Texas law to possess a firearm ammunition. Number two, beginning now, if you possess a firearm ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code, section 46.013A, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, section 46.02, unlawful carrying weapons. Penal Code, section 46.04, unlawful possession of firearm. Penal Code, section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code, section 85.026, warning on protective orders. Now, Mr. Martinez Mendoza, the written admonition that's before you is for your records. This will conclude your case. Please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
Goldman, not.
Goldman was somebody else's client. Make it.
Oh.
Other guy is McCabe.
Okay, were you looking at that? I don't have no.
Yeah, we gonna have to his bond has been, what you call that? And that's just only, he had yeah, but if you look at his paperwork, I think he had bond conditions. Look and see what cause numbers those bond conditions on. It may have been on one case, because I saw it in one file.
As long as they're draw security, I'm good.
Well, just hold up on it.
Oh, he's already gone.
Oh, he's gone? Okay. But she's gonna look up his case and see what case the bond conditions were in.
It was, and I mean, my lungs are still,
Right.
earlier pneumonia.
Doesn't help all the dust going on outside. Oh, next all, I keep losing my voice. I'm so scared to do report out today.
They're not gonna look at me.
They can't look at that, yeah. Yeah, they shouldn't have taken it, yeah.
You get that voice. So, they're at last night now. Okay.
That's it, absolutely.
We have another one? Did you have another case?
Yes, Your Honor, I do. Mr. Kyle White, he is here in the courtroom, Judge.
Kyle Reginald White, please come forward. Okay, this is cause number 23-CCCR 1796. Case is styled the state of Texas versus Kyle Reginald White. Mr. White, is that your full name? How are you doing, Mr. White? I'm doing fine. Thanks for asking, Mr. White. You're representing your case by your attorney, Attorney Marcus Wilkerson. Mr. Wilkerson, what's your announcement?
Your Honor, Mr. White, needs to come by the office to review the body cam footage in this case, and so we request just one standard reset if we may, Judge, so that it will either be resolved at the next setting or be put on the trial docket, depending on how Mr. White wants to proceed after reviewing that video.
Okay, let's put him, this case is almost, yeah.
Yeah, see, this is way back.
We may put him on the, pre-trial conference docket. Okay.
Okay.
Give us a reset.
Same file and same community service.
I'm sorry, September 30th.
September 30th
I mean,
of 2024. Okay, Mr. White, your case is gonna be reset to September 30th, 2024. Your attorney will get a copy of your reset.
Yeah.
Once you get a copy of your reset from your attorney, you'll be free to go. All right. And Mr. Wilkerson, is that your last case?
it is, Your Honor.
Okay, Ms. Wilkerson, you're free to go and you have a blessed day.
Thank you, Judge. Good to see everybody.
All right, good to see you.
Stay better.
Ain't good to see you.
Always a problem child when it comes
This is cause number M 328 422, case of style, state of Texas versus KC Harden. Ms. Harden, is that your full name?
Yes, sir, it is.
Ms. Harden, would you please raise your right hand? Ms. Harden, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Harden, you may put your hand down. How are you doing, Ms. Harden?
I'm fine, how are you?
I'm doing fine, thanks. Ms. Harden, you're represented in your case by your attorney, David Grove. Attorney Grove, how are you doing?
I'm doing real good, Judge. Thank you.
And Mr. Grove, do you waive a record in Ms. Harden's case?
Yes, sir.
Ms. Harden, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Casey Harden, on or about November 30th of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of false report to a peace officer. Ms. Harden, do you understand what you have been charged with?
Yes, sir, I do.
And to this charge, Ms. Harden, how do you plead guilty, not guilty, and no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Harden, I also have before me a document on this laptop that's titled misdemeanor plea admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? Speak up.
Yes, sir, I'm sorry.
On page 2 of this same document, there's a set of initials, KH, on the line next to boxes checked no contendory, which means no contest. Did you place your initials on this document?
Yes, sir, I did.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir, I did.
On the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir, I did.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Sir.
And is this your signature on the line that's titled defendant?
Yes, sir, I did.
Ms. Harden, before you signed and initial these documents, did you recognize these documents?
Yes, sir.
And did your attorney go over these documents with you?
Yes, sir, he
And
did.
did you read and understand everything that your attorney went over?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, it is.
Ms. Harden, are you a citizen of the United States?
Yes, sir, I am.
Yeah, for six one.
No objection.
No objection. State's Exhibit Number 1 will be admitted. Ms. Grove, you advised in counsel, Ms. Harden, is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Ms. Harden, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, I am.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. Harden, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
You do, Your Honor.
And what is the agreement?
The agreement is to 1 year deferred with a $500 fine and 80 hours community service.
Mr. Grove, were you appointed?
Yes, sir.
What is a court cost?
It's 402, that's a little high, and they're checking on.
Okay. Let's see, 7. Miss, let's see. Okay, pardon, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You will be required to pay a fine of $500 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month. Your analysis fee of $15 a month, reimbursement fee of $15. You will also be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly installments is $177 a month. Will you be able to pay the $177 each month?
I mean, I'm working on getting a job, so.
So currently you do not have a job.
Yeah, not at the moment, but I
Okay,
am.
so you're not able to pay the fees, is that correct?
Yeah, yes, sir.
Okay, now, may I see her? She should have when he was appointed. She has an
Yes, I was
affidavit of
appointed,
indigence.
Judge.
Yeah, okay, she has an affidavit of indigence that she's gonna pull up.
I have a copy of that, Judge. See that?
You have a copy of her affidavit of indigence?
Yeah, I think I do.
Okay, Ms. Harden, I have before me a document that is titled Affidavit of Indigence. Could you show this to your client? Sure. Do you recognize that document?
Yes, sir.
On page 2 of that same document, there's a set of initials, there's a signature right above the line that is titled Defender Signature. Is that your signature?
Yes, sir, it is.
Now, Ms. Harden, before you, now, is everything on that document still true and correct today?
The first page or the second?
The first page, with reference to your income and expenses.
Oh, yes, sir.
Okay, now, Ms. Harden, the court is gonna find that you're indigent. Now I have to read. That's 7.
Yes, it does.
Okay, Mr. Oh. Okay, Ms. Harden,
Yes, sir.
the court, now the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs. The court cost is $277. Now, your fine and court costs will be converted to community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. It will be converted to 62 hours of community service.
Yes, sir.
The attorney's fees in this case of $250 will be waived pursuant to Article 26.05G-11, that simply means that you will not be required to pay the $250 attorney's fees. The reimbursement fee of $15 will be waived pursuant to Article 102.018B of the Texas Code of Criminal Procedure. And so that would leave, and the court costs in this case will be reduced to the statutory minimum of $25 a month. That's the probation fee. Will be reduced from $60 a month to $25 a month.
Okay, thank you.
That's the statutory minimum. And so therefore, you will be required to pay the $15, you'll be required to pay the $15 your analysis fee each month. So it comes to a total of $44 a month. Will you be able to pay the $44 each month?
Yes, sir, that's something I can do.
Okay. Now, Ms. Harden, do you understand the state's offer and the adjustments that have been made by the court pursuant to the Texas Code of Criminal Procedure?
Yes, sir, I do understand.
And do you think that it is fair and just?
Yes, sir, I do feel like it's fair.
Okay.
And thank you.
Okay, you're welcome. Okay, hold on. What's your question?
So, the principal, you said she was not English.
Yeah, yes.
Our choice was court cost waived, but court cost is not waived, it's gonna be converted.
It's converted to communities to, yeah, 62 hours of community service. No, yeah, I hadn't finished giving her, I just did the fees. Okay. Now, Ms. Harden, you will also be required to perform your 80 hours of community service.
I understand.
So it comes to a total of 142 hours of community service. You understand?
Yes, sir.
And you will be required to adhere to the other standard terms and conditions of your probation.
Okay.
All right. Now, Ms. Harden, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, I do.
And do you accept the state's offer?
Yes, I do.
Okay, Ms. Harden, I follow the plea bargaining agreement that you've entered into with the state. Ms. Harden, you're gonna stand next to the bailiff. Please stand in front of the court coordinator. You're gonna follow just have a seat as she's redoing your paperwork. And once she finishes your paperwork, you'll be free to go and you have a blessed day. And state, you are excused.
I do want to get
All right.
one thing straight before we.
Okay.
Um, so despite the fact that Kramer is specially set number one, you're going to be placing Langston's case ahead of it?
I didn't say that.
Okay.
Yeah, but Langston case is the oldest case. Yeah. Okay. So we just need to be back. Langston is coming back in Matuska
At 1:30.
at 1:30. Yeah, we're probably gonna get a little started a little later than that because, we just get out of court. Okay. All right.
See you all.
Okay. your attorney stated that you had just finished a rehab.
Yes, sir.
What was the rehab?
Bay Area Recovery Center,
Okay,
out in Dickinson, Texas. They said, it's really a really popular one. It's one of the.
okay, how long were you in that facility?
30 days.
Okay, well, good. Now, Mr. McKay, what we're going to do, and when we went in the computer, we noticed, I mean, this is nothing for you to be alarmed at, but
Yes, sir.
what we noticed was that they had two bonds posted for you in that case. In essence, they were supposed to take it out, take one of them out, but apparently they have you posted on like two bonds
Okay.
for some reason. I don't know why. Other than the fact that somebody, when you had your bond forfeiture, they were supposed to remove the bond that you were on that was forfeited
Right.
and put it in, place the new bond in there. Apparently they got two bonds in there.
Okay.
Okay, so also, now you have these two cases, excuse me, three cases. That's 23, let me see, yeah, 23 CCCR 0865 M331910 and M334212 is Aiden B. McCabe. Now, I'm giving you some more bond conditions. And these bond conditions still include you participating, they have the Spindletop ATAR program.
Okay.
That's a drug alcohol recovery program.
Okay.
And then you have to remain drug and alcohol free. And you're gonna participate in there. They have what they call an ASAP program.
Okay.
Okay? Now you need to participate in those programs.
Yes, sir.
Your failure to participate in these programs may result in your bond being forfeited.
Yes, sir.
Now, the fact that you did seek treatment on your own is commendable on your part. It is somewhat kind of not necessarily keeping it with the bond, but it's you were attempting to do what the bond conditions required you to do.
Yes, sir.
Okay. So the court has taken that into consideration.
Thank you, sir.
And I'm going to go over these bond conditions with you. Miss Mosley, you can he's not in custody. You can take him out of. Yeah,
He's done.
he's not gonna be in, I'm gonna release him.
He might get the court note.
Hmm?
The court note.
Yes. Okay, Mr. McCaig, I'm gonna read.
Yeah, my mom's boyfriend should have it. Yeah, I'll give that out.
Okay, Mr. McKay, these bond conditions, as you're gonna get a copy of these.
Yes, sir.
Okay, say standard bond conditions in County Court Act Law number 2. And it reads as follows: following the return of criminal information in County Court Act Law number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, The offender shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of a pending offense and shall not go near any residence, school, or other location frequented by the alleged victim. Let me ask you something.
That one we didn't talk
Yeah,
about.
hold on a minute. Hold on a minute. I'm gonna look at these other bond conditions. Because I think, let me see. Oh, here it is. Okay, on the previous bond conditions, it said that you shall not communicate in a threatening or harassing manner
Yes,
with the alleged victim of the pending offense.
yes,
Is that okay?
yes, that's still fine.
Either directly, indirectly. Okay. Okay. So condition number 3, well, first of all, do you understand condition number 1?
Yes, sir.
And you understand condition number 2, that the defendant shall not shall submit to testing for drugs and alcohol at any time as directed by the court.
Yes, sir.
And the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly. Well, okay, let me read it. The defendant shall not communicate in a threatening or harassing manner, either indirect or indirectly, with the alleged victim of the pending offense. Do you understand that condition?
Yes, sir.
And I think condition number number 4 does not apply. Condition number 5 does not apply. However, condition number 6 condition number 6, you remain drug and alcohol free. Condition number, you understand that condition?
Yes, sir.
Condition number 5, you obtain and participate in the Spindletop ATAR addiction treatment and recovery program. You understand that condition?
Yes, sir.
Condition number 5, you shall participate, well, that was 5. Another condition. Let me write on here. And condition, well, number 7, you participate in the ASAP program with Spindletop Center, 2750 South H Street, Building C, Beaumont, Texas. You understand that? And condition number 8, the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay. Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Okay, you could just have a seat. I'll give you, either write this on this bond condition and give you a copy. Once you get a copy, you'll be free to go on your arrest date. And the court will be in recess till 1:30 for our trial, jury trial. Okay, in county court at law number 2, because we have large dockets in the morning, we normally don't finish until 12, like this afternoon, or today we finished at about 12:45, something around that time. And so what we normally do is start our jury trials around 1:30. Give us time to finish up what we need to finish up in the morning from our jury dockets. This morning, we had 3 dockets. We had a jury trial docket, an announcement docket, and a pretrial conference docket. Now, whether you're selected as a juror today, in this case, you're performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which requires a careful and impartial consideration of all the evidence and a correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for meals, at night, and at night. Now, I must administer the first of 2 administrative matters. So at this time, I need each and every one of you to raise your right hand, and I'll swear the panel in. And once I finish administering the oath to the panel, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors, so help you God? Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days. Ms. Mosby?
Oh, okay.
Okay. Now, I'm going to ask a series of questions, and I'm going to ask the questions in a group. And then once I finish asking the last question, then I will ask you whether or not you're disqualified under the law. Now, I just want you to answer the question to yourself. And if you think that you may be disqualified based on how you answered one of the questions, then at the end, when I ask, is there anyone disqualified under the law? If you think you may be, you'll raise your hand. We will ask you to come up before the bench, and you can stand right here on this side because we have 2 mics right here so that the court reporter can hear what is being said. And it'll be outside the presence of the other jurors. We have this device that I just put on earlier, the noise sound device. I will put that on. I will take off the mic, turn the mic off. And also we are on YouTube, so I will turn the YouTube, I'll put that on mute as well. All right. So First question, except as failure to register, are you a qualified voter in this county and state under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication probation for theft or any felony? Now, I always pause at the next question, because I'm not trying to pry into your personal affairs. This is just a question that we are required to ask by law. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your hand. Okay. Let the record reflect that no one on the panel raised their hand. Now I will proceed to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions applies to you, but you still desire to be considered as a juror, just remain seated. And once I get to the final questions, I'll ask the questions in the same manner that I asked the previous set of questions when we was trying to determine if all of you were qualified. Once I get to the last question, I was asked, is there anyone here who wished to claim an exemption? First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a pettit juror in the county during the 3-year period before today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? If anyone would like to claim an exemption, would you please raise your right hand? Okay, we have one. We have juror number 5. Mr. Garrett Ashton Bowman. Would you please come forward? Okay, is there anyone else who would like to claim an exemption? Okay. Now, at this time, we will move to excuses. Now, if you feel that there's a reason why you cannot serve as a juror, once I finish stating what the excuses are, you can raise your right hand, and then we're going to ask that you will come up to the bench to discuss your excuse with the court. Now, I'm not going to ask questions, I'll just make statements regarding excuses. First one is that a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? If you'd like to claim an excuse, please raise your right hand. Let the record reflect that no one is claiming an excuse. Let the record so reflect that all the jurors on the panel are qualified. No one other than Mr. Bowman has claimed an exemption, and no one is claiming an excuse. Okay. Let the record reflect that the court convened this case, and being cause number M333-072, the case is styled the state of Texas versus Charles Jason Kramer. Let the record reflect that the defendant, Mr. Kramer, his counsel and counsels for the state and all members of the jury are present and seated in the courtroom. Again, good afternoon, ladies and gentlemen. You have been summoned to this court as a prospective juror in this criminal case. The defendant, Mr. Charles Jason Kramer, is represented by his attorney, Mr. Ryan Matuska. The state is represented in this case by Assistant Criminal District Attorneys, Attorney Haley Simmons, who's sitting first chair, and sitting second chair is Attorney Andrew Hugel. And we have Ms. Kyle Gasper, who is also participating in this case. The court reporter is Miss Ada Christie. She's to my left. Now, she will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff is Miss Brenda Mosby. You met her earlier. The defendants stand charged by information with a Class A misdemeanor offense of resisting arrest, search, transportation. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular matter. Now, as I mentioned earlier, Mr. Kramer is charged with a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, a fine from $0 to $4,000, or a person can be given both such confinement and fine. If at any time you would prefer to not answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready to proceed? Is the defense ready to proceed?
Sir,
Now, Mr. Matuska and Ms. Simmons, is 30 minutes enough? Or do you need additional time? If you need additional time, just let me know. I'll give you additional time.
more than enough. Yeah.
Okay. So at this time, Ms. Simmons, you may proceed.
I was actually excited to come here today. I'll have some lunch. That's okay, I'll try to make it good for you. So, again, my name is Haley Simmons. I'm an assistant criminal district attorney with the state of Texas here in Jefferson County. Sitting second with me is Andrew Hugel. And here to observe and help out today is Kyle Gasper, one of our newest additions. Does anybody know anybody in the state personally? No? What about the defense side, including the defendant? We have Mr. Ryan Matuska. Anybody know Judge Holmes? Okay. One. You know Judge Holmes? Okay. That's not gonna affect any ability to be fair and impartial here today, will it?
No.
Okay. All right, so as said earlier, we're here on resisting arrest, search, transportation today. Now, what we're looking at is Texas Penal Code Section 38.03. I'm gonna go through the elements, and sometimes it might actually sound a little repetitive, and I also have the habit of talking fast. If I get that way, just tell me to slow down, I'm more than happy to slow down, okay? So coming in, what the state is required to prove here is that a person commits an offense if a person intentionally and unlawfully prevents or obstructs a person the defendant knew was a peace officer from effecting an arrest, search, or transport of the defendant by using force. And that force is against that peace officer. Does anyone have any questions while we're starting off on that? We'll follow along good. Okay. So again, repetitive, but I want to kind of pinpoint the burden the state has here today. The defendant, on or about a certain date, in Jefferson County, Texas, did intentionally and unlawfully prevent or obstruct a person that has been admitted to be a peace officer from effecting arrest, search, or transfer the defendant by using force against peace officer. It looks like a lot when you break it down, but these are the elements of the charge that we actually are required to prove beyond a reasonable doubt. So with that being said, when we're going through, and if you're selected to be a juror on this case, we'll go through each and every single one, and the state has to prove the burden on each single element. So if the state actually successfully meets that burden with each element, you're required to you're guilty on the offense. If for some reason the state were to fail to meet that burden and y'all come to a unanimous decision as jurors, you would be required to say not guilty on the offense. Can everybody do that? Can we all follow the law? So let's take a look at what prevent or obstruct means. Does anyone have an idea of what prevent might mean? Be just simple terms. What that entails. This is an interactive process. I know it seems, but I'm gonna pick on two people here, okay? So we're gonna start with you, Mr. Taylor. Is it Taylor? What's cinnamon for cinnamon in the top right now? What would be a like example of prevent?
Stopping that.
Okay. You are right on the dot. Thank you. Means to stop something or keep it from occurring. Obstruct. Y'all know this means I'm not taking the X first, right? Okay. Let's go to Lynn.
To like get in the way of.
Correct me out of maybe. Okay. Problem 1, 2, I'll let you have it. Means to make progress or activity difficult. Can everybody understand what those two mean? Okay. I know it's silly to go over these words that we may use in everyday situations, but again, these are words that for some reason you are understanding. My burden is to prove this, okay? So if at any point y'all have questions on where we're at or you're not following along, just stop me, I'll be more than happy to answer. Move on. Arrest. The taking of a person into legal custody by law enforcement must have the law. Everybody knows what arrest is, right? Right? Search. And not all of these might apply to this actual case. An act of searching or investigation by law enforcement. Transport. An act or process of transporting individuals in custody by law enforcement personnel. We're still following along? Okay. Here, let me take that to more people. Mr. Lemons. You're the winner, okay? What kind of physical actions are considered enough to be force? What would you suggest?
Resisting detainment.
Okay. What are some ways that one could resist?
Struggling as the officer puts on handcuffs.
Okay, good. So we're gonna kind of go down the line here. I want to make sure everybody knows exactly what force may mean in a situation like this. Attempting to flee or elude a police officer. Would it be threatening an officer with physical violence? Struggling with the officer while an arrest is being made? Or physically attacking an officer? How's everybody feel? Does anybody want to jump and see which one might actually be resisting? And we're talking about force here in this particular moment. Let's pick on somebody. Can't see?
Yeah, I don't want to see.
Well, let me speak. I'm gonna do better for you, okay? So we have attempting to flee and elude. Would someone suggest that that's force? Why wouldn't it be force? I see you shaking your head. Is it Miss Navarro? What would make you think that that's not force?
When you force someone to do something, he's fleeing, trying to get away, not actually.
It's not physical?
Well, yeah, no, and that time you're fleeing, no, not really physical.
Okay. I'm gonna keep speaking up for the ones that can't read. I'm so sorry that you can't. Threatening an officer with physical violence. You look like you wanna talk. What's your name? We're gonna, for the record.
George.
George, and you're number 7, right? George
Yes.
7?
That does sound more along the lines of threatening to use force, but also be ready to use force.
But you're not actually using force. in that.
You're actually using force, yeah,
Correct,
but
yeah.
it's ready to do.
Okay. Struggling with an officer. Mr. Holmes? Did you say that's force?
Yes, to resist and if it's struggling to resist.
Right. Okay, this last one, physically attacking an officer.
That would also, that qualifies usually.
That's probably a little bit worse, right? Okay. Here's what the courts have said. Texas courts have determined that any amount of physical force is sufficient for purposes of resisting arrest. Can we all kind of agree that we understand what is necessary for effect a resist warrant taking place? We have to have that physical force, right?
So
Go ahead.
the question is, they asked right here about fleeing, well, that wouldn't be considered.
That is a separate charge in and of itself. So we're here on resisting. So what we're focusing on is that actual physical force that the courts have determined is sufficient for the purposes of resisting. It's a great question though. And that was juror number 10, that's Armstead Holmes. Well, moving on. Okay, I really want to get into this one here. It is no defense to prosecution that the arrest or search was unlawful. Does anyone feel that they could not follow that law? Does anyone have a problem with that statement? Everybody's pretty much in agreement that resisting was to take place regardless, that the law does suggest that it is no defense that even if the arrest was unlawful, you can still be charged with resisting. We all understand? What are some reasons we're concerned? Why do we have this law? Can anyone tell me? Why might resisting be a law we really want to focus on?
That would be the safety of the officers.
Right. Are we worried about community safety as well? So safety of everybody around us? Good, that's perfect. That was, say for the record, that was juror number 7, Mr. Midget. Police officer safety. Suspect safety. And the general public safety. All in all, we're worried about things such as safety. What type of witnesses would you expect to see in a resisting case?
Bystanders.
Bystanders, okay. No, that's perfect. What's your name for the record? I don't know if I can pronounce it correctly. Montevino, did I say that good? All right, perfect. You're number 20. So types of eyewitnesses, bystanders, who else?
Someone with the person. Someone that's with the person.
Someone that's with them, right? Another eyewitness maybe? What about police officers? There you go. Perfect. We have eyewitnesses. We have police officers, witnesses after the fact. Now let's really focus on that officer issue right here. Would anybody give more credibility to an officer's testimony on the stand? Would you give less credibility? No credibility?
Yes, they give them the credibility that's due, because they're swearing a lot of them. They're on oath on the stand.
Okay.
They're to tell the truth.
One thing I want to pinpoint that is when you have a witness on the stand, you want to give them all the same credibility. Officers are no different than just regular old people, okay? So with that being said, that moves into my next point. Thank you, Mr. Midget. Exactly the same. We're treating our officers with the exact same. We're starting off with a certain level of credibility, right? How do we assess credibility when we have a witness on the stand? What's that? Right, facts. Well, what can we see? We see someone on the stand right here in the testimony box. What are things you're looking at to determine whether they're credible as a witness? Right? What other things? Good. Everybody agree with that? We can look to certain physical attributes to determine what type of credibility. And you're doing that with a regular eyewitness, an officer. They're all given the same way. So and I know it's small, I'm gonna keep reading it, I'm so sorry. Every witness in a criminal trial is treated the exact same. Police officers, simple witnesses, okay? They are not special. Not to be given extra weight. They're just people too. And I kind of want to pinpoint back to the fact that with that being said, officers make mistakes as well, just like anybody else. Does anybody feel that they would still not be able to give an officer either the same credibility or no credibility? Would everybody be able to give an officer's testimony the proper credibility necessary just as a regular eyewitness? Okay.
Would body cam footage be shown in that situation?
I'm actually about to get into that. Thank you. Brought me to my next point. What was that last name? Bears? Okay, Mr. Bears. What would you like to see in a resisting arrest case? What are something you want to see? If you were a juror sitting in this case, what would you want to see? You wanna see video, right? Any type of, say, body cam footage, maybe a dash cam footage, things like that. That's perfect. So stuff like that we'll be able to get in here, officer testimony, maybe witness testimony, things like that you can use to prove up your case. Let's get to something really important here, guys. Reasonable doubt. Still small, still reading for you out loud, okay? Texas law requires the state prove its case beyond a reasonable doubt. Does anyone think there's a definition for that? Good, there is not. Texas law does not allow us to give a definition of this term. It's not beyond all doubt. It's not beyond a shadow of doubt. And it's not beyond an unreasonable doubt. Best way to explain it, and I know it sounds silly, you're gonna know it when you see it. So with that being said, whenever you do go into officer testimony, maybe a witness testimony, you put together all the facts that you've gathered throughout your time sitting as a juror. You will piece together everything. And when you got that, you can use those pieces to determine common sense. I hope y'all can read that one, that was really big. So, I got one thing right there. Okay. Presumption of innocence. Who has a presumption of innocence here?
In this case,
Just in general, who has?
all of it.
Good, perfect. So with that being said, what's my job? To prove, the state has to prove beyond a reasonable doubt guilt. So when the defendant is sitting here today, he is innocent. So with that being said, the burden falls entirely on the state. The burden does not fall on the defendant. He has the right to discovery in his case. He has the right to trial, which is why we're here today. He has the right not to testify. Does anyone feel that if a defendant didn't testify, they wouldn't be able to make a determination or finding? Good. He has the right to exculpatory evidence, and he has the right to proper defenses. Can everybody go ahead and agree that we all know that the defendant here has rights? Yes. Good. So that brings me to the jury's duty. Go ahead.
It's the same rights everyone else has.
There you go. Jury's duty. If you're selected for this case, it's your job to decide the facts, apply the facts to the law, and then follow the law. That being said, does anybody have any concerns in terms of not being able to follow the law? No, please.
My job is to ensure that my workplace follows the law as best they can.
Pretty much everywhere, right?
Yeah.
And don't be scared to talk. Not talking doesn't save you from getting picked for a jury. I'm just gonna tell you that now. There really is no secret around it. It really, really depends. But with that being said, well, does anyone feel for religious purposes or other reasons they could not sit in judgment of another? Maybe y'all are scared to talk, but just be honest with me. Really, the thing about Fort Dyers is conversation. It might sound like we're drilling you, that's fair, but we're really just trying to get to know you and see if you're the best fit for this case. So as I close out, does anybody have any questions for me? Everybody feel they can be fair and impartial in this case? All right, thank you so much for your time.
Mr. Matusa, you may proceed.
Your Honor, if I may, just give 1 second to switch computers.
Okay.
Maybe.
It's mostly.
You want to go about that? Okay.
Turn off,
No, no, I mean, this is kind of.
No. Fine. We'll just move on with it. Good afternoon, folks. Thanks for being here. There's a capital murder going on down the hall. Anyone excited they came down here for resisting arrest? Those of you that didn't make it down there, I'm sorry. But this would be a shorter trial. How about that? We're a little happier about that, not 2 weeks. My name's Ryan Machuska. It's a pleasure to be here representing Mr. Kramer. I am obviously the defense attorney. And as Ms. Simmons said, the government does have the burden. And that burden, as she accurately described, is a big burden. Now, does anyone disagree with that? Let me see who didn't talk. Ms. Edmond, you didn't say a word. So, could you describe to me in your own words what that burden is for the government? Beyond a reasonable doubt. Now, she also said something important about beyond a reasonable doubt. And that the definition is unique. What was that? She did, you know it when you'll see it, common sense. And sometimes I go to Walmart. Y'all ever go to Walmart? Does everyone have common sense at Walmart? Unfortunately not. You tell me, Miss Edmonds. How do you feel? You ever go to Walmart? How do you feel about common sense in the parking lot of Walmart?
Not so common.
It's not so common. Why is that?
Some people, they think differently.
We're all different. And that helps us in jury duty, right? We all have the education, experience, all kinds of unique stuff that we blend together when we go back and deliberate. So, Ms. Edmond, one more question. I'll leave you alone.
Yeah.
Now, we have cornerstone of our judicial system. And very important when we begin the case. Now, these two tables right here are kind of on the same line, right? They're even. But is the case starting out even? Should be? Why is that?
Because like you said, you should look at everything that you want everybody to see everything.
Okay. Thank you. Mr. Holmes, what? Not that, you're close. I tried, I thought I was gonna get that one wrong. Those only guns and horseshoes and hand grenades. If we're starting out by saying Miss Kramer's innocent, which we are, right? So we agree or disagree? You are. I'm asking you. Well, I don't know, because I haven't really been tested. Okay, now we're getting somewhere. Tell me about that. Can't pass judgment on something you know nothing about. Okay. Should be self-evident, but, state will state their case and present the evidence. You will turn around and defend your client against it. Until we got both sides of it, we can't make a judgment on it. So you're telling me we have to prove what? They have to prove guilt, you have to prove innocence. Could I see a show of hands of anyone that agrees with that statement? Okay, and Mr. Sudella? Is that right? Yes, sir. Tell me how you feel about that statement. Sounds good to me. Why? I guess it's how it's supposed to be. And how is it supposed to be? One side arguing with the other. Equally. Yeah. Is that what you're saying? Yeah. Okay. Anyone else? Agree or disagree? How about you, Mr. Boardwalk?
You don't have to prove anything. Or they have to prove that he's guilty. You don't have to prove his guilt or innocence,
Why do you feel that way?
because they have the burden. They have to supply the evidence for us to decide whether he's guilty or not.
Okay. Thank you. Anyone disagree with Ms. Bordelon? Besides you, besides you. Okay. I'll pick someone. Mr. James. Tell me in your own words how you feel. You agree or disagree with Ms. Bordelon?
I agree, it's innocent until proven guilty.
All right, so if that's the case, are we starting at the same line? And government a little bit behind?
I would say they were a little bit behind because they have the burden to prove his guilt.
Now, how do you feel about that? That the government's actually starting a little behind?
I don't know how it's been that way for years, so I guess it's their job to do that, I guess that's where they're.
Well, we've all
Or, you know,
been in other countries, right? Have you ever been in other?
I don't know.
Never.
Never.
You need to go somewhere.
I know.
You ever left Texas?
Oh, I love Texas.
I don't know why you need to really, but you never, anyone else never been out of the country? Okay, 1, 2, 3, 4, 5, 6, 7. Well, I just want to get it all. All right, who has been out of the country? All right, I'm gonna. Mr. Midget, how about that?
I have lived in the Caribbean for about 3.5 years.
You did that same
When I was
right?
a kid.
Is it midget or is it?
Midget.
Okay.
That was a long time ago, back when I was a teenager.
What do you know about the laws?
Not much. I do know that there was a British colony, Crown colony. And beyond that, I didn't really pay attention to the laws.
So a little similar to what we do.
As a kid, you know, kids aren't gonna pay attention too much. No, they drive on the wrong side of the road for the United States, but that's because they drive on the left-hand side.
I've never been. Really. I have been to Mexico though. Anyone been to Mexico? Right here by Mexico. And when you're in Mexico, is misspelled? Did you feel like things were a little different? Legal?
Very much so.
Tell me about it.
I didn't feel as safe. Because, you know, if you don't know the laws or anything, you just kind of like behave and use common sense, but I don't know. It's kind of a scary thing. They don't drive well, I know that.
Well,
They're comfortable over there. They just drive well, other than that, I love it. I mean, that's no problem.
now, a little different sense of security. That's kind of what you're saying. And in regards to the police, did you ever run across the police there?
No.
No, did you see anyone there interacting with the police?
No,
Not much of a police presence at all, really?
no, not in our Purdue. I was just vacation.
Okay.
But I didn't see any police presence in there.
Now, I want to ask y'all something. about prior jury service, because it looks like a lot of people have actually done this before, including you, Mr. Taylor. Ms. Taylor, could you tell me a little bit about that experience? What kind of case was it, a criminal case? And how is that experience for you?
About a decade ago. My first prior jury.
What kind of case was it, federal, state?
I think it was state.
And were you able to reach a verdict on that case? Okay. Anything negative about that experience? Or anything in particular that you remember?
Yes, that one, we could not prove without a reasonable doubt.
And I guess that was mainly because the evidence, or you guys, I guess, stuck to that burden, so we know a lot about that. Okay. Did you say it was a felony or misdemeanor?
I think it was a felony.
Mrs. Borderline, you've been on the jury. Were you able to reach a verdict on that case too?
Yes.
Could you tell us how that experience was for you?
I've done it a couple of times, about 30 years ago, February, criminal. And about a year or so ago,
Okay, so anything negative about the criminal experience, you know, jury?
No.
Okay, thank you. And, Ms. Vernon, how about you? You said you've been on jury too? Okay, and about how long ago was that?
maybe a year or two.
Oh, not that long. Okay, was it here in Jefferson County? Were you able to reach a verdict on that case? How was that experience? Yeah, okay,
I like the court system.
okay.
It was educational.
Educational, but nothing negative about that experience. I think that's it. Anyone else? Oh, I have the chocolate down here.
I was, on a capital murder case in Jefferson County, I guess about 2 years ago.
2 years ago.
I believe 2 years.
Okay. How was that?
It was intense.
Was it long?
I think it lasted right like 4 or 5 days, I believe it was.
Okay, so a whole week.
Yeah.
Pretty much.
Just,
All right, and were you able to come to a verdict on that? Was that experience?
I go with that interesting, the first time I've ever sat on a jury.
You went
and I
right
get the
into
first-
capital.
Yeah, so it was a lot to take in, and, especially when you get back and you're all together. I mean, you have some that you can tell sat through the whole thing and, didn't really pay attention. You know, a few of us that were like, just can't be good, so cut and dry. I mean, it was an interesting, I hate to say the word neat, but it was really neat to be part of. I mean, I always get flack from my wife or coworkers, I can't believe you did a jury duty. I mean, and I'm like, if I'm ever on the other side of it, I want, like I said, a mixture of this community, of people here, good heads on their shoulders. I mean,
We have a good mixture, I think. I've been doing this for 15 years now, and I think our county's special. Mr. Mull, so thank you for sharing that with us. Also, it looks like some of y'all have law enforcement contacts in your family or in your friends. And let me see, Ms. Borderline, do you?
My sister-in-law, she's retired.
Okay. And I know Ms. Simmons asked this question earlier, but I want to ask you, would you give an officer more credibility on the stand than a normal witness?
No.
What is it?
Thank you for anybody else saying themselves.
Okay. And that relationship wouldn't affect you in making a determination of guilt or innocence here. Thank you. Ms. Vernon?
Yeah.
You also? Who's your friend or family?
Uncle.
Uncle? Who's your uncle do?
He's a police officer in Philadelphia.
Philadelphia? Did y'all share much of his life and his career together? Do you know much about that? And would that affect you in being a juror in any way?
No.
And, how about, Mrs. Morrow? How about you?
President, Captain Austin.
Captain? Okay, and same question. Would affect your ability to. And, Mr. Barnes, or Bears? Is it Bears?
Bears.
Okay, who's your
Nephew,
nephew?
state trooper.
Here?
Yeah.
Nephew.
That's me.
Hussey? Buddies with Hussey.
You know him?
Oh, yeah, I was just talking bad about him yesterday, I actually. Ripped a bumper off my brother-in-law's. Big, he's a good guy. Would that affect you in any way? Being a juror, knowing Mr. Hussey, what is he now? Captain or something? He just keeps getting quiet. He's a good guy. And Mr. James.
Yeah, my uncle was a retired detective from Dallas.
To Dallas? And same question. Yeah, would affect you in being a juror on this case? Okay. Well, I appreciate y'all giving me that information. So y'all heard this is a resisting case. And we don't try a lot of resisting cases that I know of. I don't try many of them. I don't see many people try many of them, but this is a unique case. And the government, as we talked about, is going to provide y'all with some evidence. But before we get into that evidence, I want to ask you a little bit about what that means to you guys. So, Mr. Lemons, you spoke earlier, you said struggling as the officer puts handcuffs on you. Could you tell me about that a little more?
Whenever an officer is trying to detain you, you should allow them to do so that they can carry out their duty.
Just period. Doesn't matter anything.
Well, it's the officer's job, if they're telling you to do something, how to do it, so they can carry out their job and go ahead and get it over with.
Okay. Anyone else? I'm gonna start, Mr. Midget. How do you feel about this?
Just arrest versus, it really comes down to the safety of everyone involved. Resist the arrest, chances of someone else getting hurt, officer with the person being arrested, or someone that's on the sidelines. Can't happen. And resisting is not a very good idea.
Thank you. And to be fair to Mr. Lemons, he said something very specific, which was, what, Mr. Lemons? What did you picture? You picture putting cuffs on, right? Is that how you define it? The arrest.
That is being detained. Being arrested is being transported to a local facility.
Okay, and tell me the difference.
Detainment is more temporary, whereas an arrest, the officer has already established that a crime has occurred or potentially occurred, and they need to remove somebody from the situation.
Okay. Thank you for explaining that. Mr. Holmes. Do you agree or disagree with that statement?
I agree with what he said.
Is there a difference to you?
Being arrested and detained. Well, if a person is detained, they just hold them up, to find more information about them. If they are arrested, then they're gonna take them to the detained place.
Okay,
Jailhouse,
but would that matter to you in making the determination of guilt or innocence?
Being said detained, arrested.
Yes, sir.
No, I would have to hear the evidence. In order to make a judgment, I'd have to listen to what's being said, why, what created the problem and all of that.
Yes, sir. And Ms. Navarro, would it matter what the person's frame of mind was or knowledge of why they were being detained, matter to you?
No, because I look at it as, you fight in court. They tell you you're under arrest, you do it, and then you fight in court, if you don't, if you think you're gonna do, what they say.
Okay. So explain to me when you should know.
You get pulled over with whatever you're doing, but
Okay.
it's coming to you.
When you get pulled over, one example, Mr. Constable, could you give me an example? And Ms. Navarro said, when you get pulled over and you're told.
Been very done.
Yeah. So tell me what you think it should be.
Pulling over is probable cause. Unless you've got the insurance in your vehicle to demonstrate the law is violated.
You got a radar machine in your car. Or camcorder. Something like this. You're following the vehicle. There's some way to determine that that vehicle is driving in excess of a posted speed limit. And you do have the right to pull it over.
And the officer in those situations relying on his radar. Right.
Right.
That's what you mean, he's relying on information. But we're talking about not pulling you over, not fleeing, talking about resisting, talking about handcuffs. How you feel about that?
You're being detained. And you're placed in handcuffs. You're technically under arrest. If you're being detained in a way that allows the officer to turn around and go and do what he's doing, it's still an interference.
Okay, thank you. Mr. Bears. You agree or disagree with this thing?
I just think you're, you know, if you get pulled over and you get detained, you'll either stay in the vehicle while they, you know, check your records, and then they'll come back if there's a reason for them. If they have probable cause or suspicion that something else is about, they may ask you to step out of the vehicle. At that point, they may ask you to complete a search of the vehicle. Some point, they're being detained there, and at some point, you're gonna go through being arrested, and then they'll start reading your rights.
How do you feel about if there are other persons around?
In the vehicle?
Sure. Or anywhere that you're thinking of.
Depends on what's going on in the vehicle.
Okay. And would it matter to you, how do you feel about the officer's responsibility of notifying you of why you're being detained or arrested? Mr. Patterson, have you said anything yet? Oh, yeah, I'm sorry, I feel weird. I was getting there. You're 13, yeah, I like your number. So how do you feel about that scenario? And, I know we're all imagining our own picture, but that's kind of where I'm getting at. What do you picture there?
Guess you kind of gotta go back to the very beginning of, you know, why they, if there was a scenario of getting pulled over, why was he pulled over, and was there evidence for the reason of being pulled over? And then not only that, but I do think that you need to be told the reason, you know, why they would be going further into whatever that means. Yes, looking or actually being arrested, you should be ready to ride.
Okay, thank you. Go on. No. How do you feel about a misunderstanding between the person getting arrested and the police officer?
By
even where there's laws set in place, if you follow them, you can end up in court where you can actually figure that out like they were saying.
Does it matter to you where it is? Well, some places are more private to us than others. Does it matter where it is? We had an example of a car, but
Public location.
anywhere.
If they have a reason to believe that something could be going wrong, being detained, making sure that everybody is safe, brought in, arrested, and then at that point, we can start figuring out truth from accusation.
So how do you feel about just not asking any questions to the officer?
I think it depends. Obviously, if you're being hostile, it becomes alarming. If you are, detained, set aside, and you're just like trying to ask questions, I don't think in that situation there's necessarily anything wrong with it, but I've also never been put in that situation.
Tell me why.
Why I haven't?
No, why this, you said the scenario matters. But just,
Yeah, I
your
remember.
feelings are, and that's fine, that's kind of what I want to know. Is that you're okay with just simply saying, you want to arrest me, right? And your response is, yes, officer. Okay. And so, am I correct in interpreting your answer is that that's what we need to follow orders?
Safer for everyone involved,
Safer for everyone?
the officer and whoever is being in any kind of raise and, I guess, escalation of the situation can make things go very long.
Okay, thank you. Mr. James, how do you feel about that safety issue?
I agree with her. It was, I think on the previous slideshow, it did say where there was a law that no matter, or regardless of the arrest being lawful or unlawful, you're still supposed to comply with the officer. And so I think in that scenario, I agree with her. There's a difference between resisting arrest and asking questions.
Tell me about that.
Well, I think resisting arrest was the use of force, asking questions, and I might be wrong, but is it the officer's duty to answer those questions?
Well, we didn't go into that part because there's a lot, you saw the law. Okay, it didn't say that. Okay, the officer is relying on something. But what that is, how do you feel about it?
What do you mean the officer relying on something?
Well, what is it that the officer is relying on that's important to you? Or does it matter? It's up to you.
I think it matters, but again, it's going back to that original law or that law. And the difference between just having a conversation and asking questions about why the situation is unfolding and then using force to resist.
Thank you. And Mr. Taylor, how do you feel about that safety issue, an officer being scared?
Scared enough to.
Does it factor?
Long, but if the officer is scared, there could be some circumstances where.
Or do you feel like that's even a factor at all?
I think it should be a factor.
Well,
At the end of the day. For safety purposes. The person should follow the law.
In for safety purposes, what do you mean exactly? What are you thinking there?
The officer has a reason he believes that someone needs to be arrested. Even if it's bogus or that's something for the courts to decide.
Thank you. Ms. Borderline, is there any wiggle room there, or do you agree with that?
I would think somebody's being aggressive enough for a police officer to be scared, then they aren't taking safety of anybody around themselves, the person that they're trying to detain, to arrest them. So nothing can escalate any farther than what it already has.
Is that important to you?
Yes,
And why?
safety
And for the officer or
for the officer, for the detainee, for anybody around.
Thank you. Ms. Vernon, how important is it that an officer has control of the situation?
Very important.
Why?
Because you could be liable for doing something to you.
That is a good point that nobody has mentioned yet, right? Why is that important to you?
Because he's supposed to uphold the law this way.
Ms. Clark. You the only one? I've had an answer yet? I think you are. I almost made it.
Oh.
I want. So Ms. Vernon brought up maybe in Ms. Vernon, they're not being sure about something. How do you feel about that fact?
I think a police officer has probable cause. Whether we agree with it or not. Yeah, I mean, I'm not gonna speak for everyone, but I mean, I think it's all, what we're all thinking is, why did this happen? You know, did, stop at a stop sign? There was probable cause. Police officer goes up to the window, says, I need your license and registration. He refuses. Then that's probable cause to detainment. And then if it escalates from there, then I would believe, I don't know, but I would believe that therein the officer would have the wherewithal to make an arrest until registration, license, identity was provided, or whatever the case may be. But I do agree, that the officer has, needs to have the wherewithal to keep the calm, not let it escalate.
The control.
In control. And the person that's being pulled over, I think that you have to, it's humanity to ask, why did you pull me over? I think,
Why is that humane?
well, I think it's a human reaction in that, you're okay, fine. I'm going 70 into 65, but I didn't realize it. And then I get pulled over and you say, why did you pull me over? You ask the question. Does he answer the question? I'm not sure if he has to or not. But then you go from there, you go through the stages, give me your registration, your identity, and then it rolls on from there.
Would you define this scenario of resisting as objective or subjective?
I'm gonna be elusive. I think it could be both.
Okay, that's fair. Tell me why.
Well, because I think subjective is all relative to the officer and it's relative to the detainee or arrestee. And then the other is which way do you fall? In that he had a right to ask, or he had a right to detain, or he had a right to keep asking, and then he had a right to arrest.
Well spoken, I
Well,
appreciate that.
I think it was elusive, but thank you.
I saved your best for last, Larry.
I tried that.
Thank you.
You bet.
And, And thank you all. I want to leave you all an opportunity. I know when we start this trial, you won't be able to ask a lot of questions except kind of by committee. And that'll go to the judge. And now, if y'all have any questions, you've heard about the prosecutors. Y'all have any questions?
I would have a question, and it may not be pertaining to this. The police officer stop you. Do you have the right to retrieve information to the police officer? If you don't, have a proper call for stopping you?
So let me back up a bit and start by answering that we have levels of proof in all courtrooms. Some of y'all have been on civil juries, understand. They've heard preponderance of the evidence down there. Here it's beyond a reasonable doubt. Reasonable suspicion is what they need to pull you over. And that is the first step, yeah. And then when we get past that step, the next step the officer needs to articulate is probable cause. And that officer can then arrest you. The officer to stop you, and we've discussed this, reasonable suspicion is what they need. The next step up to there is the scales. Just 51%. That's preponderance of the evidence. Y'all heard that one, I know. We get even higher than that. We have a definition in Texas that is clear and convincing. And we use the standard in family court where the government can take your children. The last step, the highest step is for your freedom. And that is beyond a reasonable doubt. So, and that is in this context, in criminal court, we're talking about a person's criminal potential record that they could have to run through their life and their freedom. But reasonable suspicion would be to pull you over. So your question on probable cause would come to the arrest. So in that context, does that change your question?
I guess that's pretty close to, you know.
Right. Yeah, an officer would then need probable cause, the next level of it, to arrest you. Yes, sir. And then send the charges after that. But as far as the jury is concerned, fact finder in a criminal case, we don't define beyond reasonable doubt in Texas. The penal code does not have a definition of that. And basically, it definitely is. Some federal jurisdictions in the United States actually do have a definition of that, but Texas does. We just know the definition is beyond clear and convincing. And that is enough evidence for the government to take your children. Other than that, that's the highest burden that we have in Texas. Good question. Anyone else? Good, Nick Kelly.
Okay. Okay, ladies and gentlemen of the jury panel, I'm gonna ask that you step outside and follow the bailiff. And we may have to call some of you back in to do some follow-up questions. So you can go out either one of the doors, either the door where the bailiff is, or you can come in the door that you came out. Comes in. Ms. Bill, if you can call it, get the panel, they can sit where they were sitting earlier.
Exactly, okay.
Okay. Y'all may be seated. The court is back in session and calls number M 333-072. Case is styled the state of Texas versus Charles Jason Kramer. Let the record reflect that Mr. Kramer is present in court with his attorney, Attorney Ryan Matuska. Let the record reflect that the state is also present with Assistant District Attorney Haley Simmons, Attorney Andrew Hubel, and Ms. Kyle Gasper. State, are you ready?
Thanks, Your Honor.
Defense, are you ready?
Ready, Your Honor.
Let the record reflect that the panel is also seated and present in the courtroom. Ladies and gentlemen of the panel, we're going to call some names. If your name is called, please come up to the jury box. There are some badges, some black badges on the top. You can take one of the badges and pin it to your clothing. At this time, you'll now be in the hands of Miss Trina Redmond.
Good afternoon. When I call your name, please have a seat in the jury box. Ethan Taylor,
Ethan Taylor, would you please come forward? Taylor, you can get a badge.
Deanna Vernon,
Deanna Vernon, please come forward. Get one of those badges.
Akila Edmond,
Akila Edmond,
George Midget,
George Midget, Midget, you can get one of those badges.
Samuel Bear,
Badge, you can come forward. Get one of those badges.
James Glenn,
You need another badge.
Amanda Tumo.
Okay, ladies and gentlemen of the jury, I must administer you the second of the two oaths that I mentioned to you earlier. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do each of you do solemnly swear that in the case of the state of Texas versus Charles Jason Kramer, you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You may believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her. The attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from sources outside of this courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. You have badges identifying you as a juror in this case. Please wear those badges at all times. Ladies and gentlemen of the panel, those of you who are not selected to serve as jurors in this particular case, on behalf of the citizens of Jefferson County, behalf of the staff here in County Court at Law Number 2, I would like to thank you for taking time out from your busy schedules to be here this afternoon. Without citizens like you, our criminal justice system cannot function. And so therefore, it's because of people like you who take time out from your busy schedules to come here to make sure that justice is done, we are able to administer justice. So anytime that you're in the neighborhood, in this courthouse, please feel free to come and have a seat, or you can watch the case on YouTube. Now, I know that when you came here this afternoon, you probably looked over the door and you saw that this was County Court at Law Number 2. And you probably said to yourself, oh, this is Judge Holmes' court. Well, this is not my court, this is your court. I'm only a public servant serving the citizens of Jefferson County. So anytime that you're in the neighborhood or in the area, County Court at Law Number 2, you can come and have a seat in your courtroom. Now, that area that you're sitting in, we call that the peanut gallery. But it doesn't mean that you can bring peanuts in here and eat, because this is not the Texas Roadhouse. So anytime you're in your area, just have a seat in your courtroom and see what goes on in Jefferson County. And I would tell you, you'll find that there are some very interesting things that go on in our community. Now, the court bailiff, she has some letters that she's going to give you. Please take those letters, and if you have any comments, you can just drop us a line and we'll read any comments that you have. Now, if you need something like an excuse or to show your job, the district clerk's office is open. It's right across the hall. They can provide you with any excuse that you need. And if they're not open, you can come back to this courtroom and we'll be happy to get someone to provide you with that excuse. Again, ladies and gentlemen, thank you for being here this afternoon. This will conclude your jury service. And as I so often do, I usually shake hands, but we still have COVID in our community. Matter of fact, they say the numbers are going back up. But I would like at this time give everyone what I call an air handshake. So ladies and gentlemen, thank you for coming here. And you're now in the hands of the bailiff. You're excused, and everyone, please have a blessed day. And it's good seeing you, Reverend Holmes. God bless you. Okay, now state, you're gonna be calling your first witness tomorrow?
Yes, Your Honor.
Okay. So ladies and gentlemen of the jury, we're gonna ask that you come back tomorrow. That's when we're gonna start the testimony in the trial. Be here for 1:30. That's the time you have to come in?
Yes, Your Honor.
Okay. Be back at 1:30. Make sure that you sit out in the hall near the courtroom, and the bailiff is gonna come out. And then when she's ready for you to come in, she's gonna ask you to come in. Make sure that you wear your badges. Okay, so that y'all can take them with you. And so that they'll identify you when you come into the courthouse. Everyone will know that you're serving on a jury in County Court at Law Number 2. All right, so we're going to take a break. At this time, the court will be in recess until 1:30 on tomorrow. Everyone, please stand as the jury exit the courtroom. Okay, the court will be in recess until 1:30 tomorrow. You're welcome.